There's some urgency, Your Lordship. My land has been requisition. I prefer an appeal. Now, without disposing the appeal, they want to
Bench 5 matter.
bench.
Your land has been requisition is a bench 5 matter, not bench 4.
May it please your lordship, I have filed an additional affidavit in item number supply 16 motion. That may be, I'm deeply obliged, your lordship.
Repeat, in regards to item number 39, we filed an affidavit in reply that will be correct.
May please, Lordship. Lordship, item number 9, Lordship. Today I have filed a affidavit. Lordship, matter may adjourn for the day, Lordship. Item 9, Lordship. Today I have filed.
What you have filed?
Affidavit in reply, Lordship.
Huh?
Affidavit in reply. I am for the petitioner, Lordship.
So what? Let's see.
May I please, your lordship? I
Obliged.
beg to mention item number 68 of the supplementary list. So I want to file a reply. The respondent side has filed their objections that has been taken today with the record.
Let's see when the matter reaches.
May please, your lordship. I beg to mention for listing of a writ petition for your lordship on 19th of August, your lordship. The matter, 19th of August, your lordship.
Why?
There is some urgency in this matter, your lordship. The PW authority has in possession of my land without there being any acquisition process, your lordship.
So bench 5 matter, not here.
Deeply obliged, your lordship.
Bench 4 no hoy jana. Ki bench?
May I please, Your Lordship.
Ki bench? 4 5 nahi. I bohane nahi. Bench 5 বলছে না। Bench 5 বলছে। তুই bench 4 কোনে লিখছিস?
May I please, Your Lordship? My lord, this case relates to the non-payment of higher charge, my lord.
Huh?
Non-payment of higher charge.
Okay, notice. Notice.
They were supposed to be on the.
No, it is there in the page 15. Page 15, it is there, my lord.
No, we issue notice first. Notice to police or case. Police?
Yes.
Okay. 2nd November.
2 is also same.
2nd November.
2 is also same, my lord. Before second. line.
Item number 3, Your Lordship. Request for a passover, Lordship. Arguing counsel is on his way. Due to some waterlogging, he got delayed.
Water logging?
Yes, he's coming from Horumoto area, so there was some waterlogging outside his house, so he got stuck. Just a short passover.
Chalo.
A non-payment of contract bill, my lord. NGO done, my lord. Individual household, my lord.
What is your matter about?
My lord. Initially, my lord, work order was allotted to the petitioner by the assistant executive engineer, my lord. Work was
Work
completed
order of the year
to 2020, my lord.
issued by
Issued by, my lord, assistant executive engineer. Member secretary,
where is the
page, my
work
lord,
order?
27, my lord.
Where is the PHC council? You are PHC?
I appear on behalf of Mr. R. Gogoi. I appear on behalf of Mr. R. Gogoi.
Where is he?
He's not available today due to some personal exigency.
Any other PHC council?
Because everyone's on legs. They're on legs, Milos, at the moment.
This is for non-payment.
Yes, my lord. Yes.
Who are on legs?
My lord, Mr. I. Thakur is on legs. And
I bought a accept for leave. 4th of November. Notice. 4th of November.
5 also same, my lord. 5, 6, and 58. 58. 5, 6, and 58. 58. Supplementary.
These are all non-payment of dues.
Yes, same, my lord. Same. It's just a
So who
different.
are there? This is the PHE is there and state is there. Give your names. I Thakur is for PHE and you for state.
Rajmat.
May I please your lordship. My lord, the petitioner is the owner of furniture shop, my lord. His articles of his shop were, my lord, on 3/7/2026 has been seized by the respondent number 3, my lord, without any prior notice, my lord. There are similar other matters, my lord, which are also pending before this honorable court, my lord, fixed on 14/8, my lord.
This is by Forest,
My lord.
Forest Council. It has been seized, then why you are not going before the trial court? Before the court asking for Jimma and all.
My lord, they also threatened me not to operate my shop, my lord,
There's
despite.
no mention out there.
Yes, my lord, I have given the statements in the
You are
petition.
operating your shop where?
My lord, in Dekiajuli, my lord, in Shoditpur district.
Is it within the forest area?
No, my lord, it is in the town, my lord.
Show me where is it?
My lord, in Para 2, my lord, I have given the address of the shop, my lord.
Why will the forest, where is the order of forest?
Page 22, my lord. There is a seizure list, my lord.
Page?
22, my lord. They have mentioned some violations, my lord, without any specific mentioning, my lord.
So if this is a seizure being made under the AFR,
My lord.
why you are not before this, before the officer,
My lord, we have also visited there, my lord.
before the court, asking for release?
In this
Why
stage,
you are here?
they have also, my lord, issued a notice for confiscation, my lord. Also, they have threatened
So
not.
confiscation proceedings, if it is there,
Yes, my lord.
as per the so and so, it is generated that all furniture units under so and so production AI inform you that all furniture units will register your furniture under so and so within 1 month.
My lord,
So you have not registered.
I have already, my lord, registered. I have annexed the acknowledgement received on page 24, my lord. When I got to inform, my lord, the
This
requirement.
registration is done much after.
Actually, my lord,
You registered on 23/7.
the
The
require.
teaser was made on 3/7.
Yes,
Then
ma'am.
it is apparently clear that you have not done so.
My lord, actually, what has happened, my lord, they have not, my lord, informed us, my lord, about the requirement
It
of
is the law.
registration, my lord.
It is the law. Do they need to inform you? Tomorrow, you commit a murder and you say that I have not been informed about the BNS. Can
Similarly,
it
my
be
lord, I
the
have
justification?
immediately, my lord, I have applied for the registration.
But you have done so. So therefore, now isn't it your requirement to approach the concerned jurisdictional magistrate out there
That is,
before whom the Caesar list must have been placed?
yes, my lord.
Then-
That is there, my lord.
Why should this court entertain 226 in this matter?
But my lord, they have also threatened me not to operate my shop, my lord.
Obviously, now you are registered, they will allow you.
My lord, I am.
Say anything. Where's your counsel?
He's still on legs. I have.
We do one thing. We stayed here on account of the PHE, the forest not being present. We stayed there. Caesar, hand over the possession back to him. You don't have any instructions, so
Does
therefore
not-
state. Direct you not to disturb his. Where is the confiscation notice?
My lord, page 25, my lord.
Thereafter, you have registered yourself on 23/7.
My lord, thereafter I only came
Why
to
are you
know.
not going there?
Actually, my lord,
Why should this court entertain this type of writ petition? Yes, Mr. Bhattakur. Don't leave it. Give these young advocates who have nothing to do out here. They cannot take notice on behalf of the PHE or the Forest Department.
I will
If
take.
they
note.
say anything out here, they will be in trouble. Don't you think so? It is an absolute irresponsibility of the forest councils. Now tell me, why they are not moving before the magistrate? Are you aware of the facts or of the case or not?
I'm aware, my lord.
Then why they are not moving before the magistrate? Why should this court entertain this type of petition?
And notices have been issued, my lord, in this case.
Then you go there.
my lord, similar other matters are also pending.
Forget about that. You bring those similar matters, we dismiss. Give the numbers.
On 14, my lord, they are, my lord, fixed, my lord, on 14th
Give
of.
those numbers. Item.
my
We
lord.
dismiss those petitions also.
Actually, my
You
lord,
have been issued a confiscation notice. So you have been asked out there to go and appear in, what is it you are asked? You are hereby called upon to produce legally and proof of origin of the forest produce as per the provisions of the rules and regulations having force in law seized from so and so. So you have to go there.
my lord, we have approached them, my lord, but received no
When?
response, my lord. After issuance of the confiscation notice, my lord, our contention in the present writ petition is, my lord, whether the seizure of the respondent number 3 is violative to the principles of natural justice or not, my lord. Without any prior notice.
Where is your reply to the show cause? Page 25 is the show cause notice.
Yes, my lord.
We do one thing. Along with you, the other matters also, we pull it up on Wednesday and finish off one day.
My lord,
All these matters.
all are fixed on 14, my lord.
Huh?
Let this matter.
Forget
also-
about that. We bring it before that and finish it off. Unnecessary 14, not necessary.
May be taken up together, my lord.
We dismiss it right away.
Oh, my lord.
No,
Let
No.
my senior, my lord, appear on 14, my lord, along with the other matters, my lord.
sorry. No case made out. Are you prepared with your matter or not?
I'm prepared, man.
Argue?
Yes.
Argue?
And notice has been issued and they merely have to participate in the proceedings. That
Yes,
is,
that's it. He has made his argument. Never heard Mr. So-and-so. And even this notice also, you have not challenged it.
My lord, that was, my lord, subsequently delivered.
You
to
have not
me.
challenged that notice also.
Yes, my lord.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Aibo Thakur appears on behalf of the respondent numbers 1 to 4, 1, 2, 3, and 4. Mr. So-and-so appears for respondent number 1. The petitioner has filed the instant writ petition challenging the seizure of the various articles from the petitioner's shop on 3/7/2026. The petitioner have also sought for restraining the respondents from confiscating the seized articles. The brief facts of the present case is that the petitioner claims to be a manufacturer cum retail seller of wooden furniture items with the trade name Dhekiajuli Furniture House, situated at Ward number 6, Dhekiajuli town in the district of Honipur. It is claimed by the petitioner that the said shop was inaugurated on 4/5/2026. On 3/7/2026, the respondent number 3 and their official staff, without any prior notice, came to the petitioner's business premises and seized all the articles without assigning any specific reason. The petitioner have been also provided with a seizure list dated 3/7/2026, wherein it is mentioned that the seizure was carried out on account of violation of the provisions of the Assam Forest Regulations 1891, read with the Assam Wood-Based Industry Promotion and Development Rules 2022. It is the further case of the petitioner that on 23/7/2026, the petitioner registered itself under the provisions of a rules ko na naam to di di. By making an online payment. Be that as it may, on 13/7/2026, a proceedings have been initiated against the petitioner on the basis of the seizure carried out on 3/7/2026. And the petitioner was asked to show cause as to why the seized article should not be confiscated to the state. The petitioner thereupon have approached this court by filing the present writ petition. This court duly takes note of that the Assam Forest Regulation 1891 provides and empowers the officials of the Forest Department to carry out seizure, search and seizure, and also thereupon confiscate. The powers of confiscation is initiated on the basis of a show cause notice. In the instant case, a show cause notice had been issued to the petitioner on 13/7/2026. The petitioner, rather replying to the said show cause notice, has approached this court by filing the present writ petition. It is the opinion of this court that the petitioner it is the opinion of this court that in the present facts of the case, the entertaining of the instant writ petition on the basis of a show cause notice would not be in the interest of justice. Further to that, the petitioner has adequate statutory remedies against the seizure carried out on 3/7/2026. Under such circumstances, this court therefore is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed. Before parting with the record, this court finds it relevant to observe that the dismissal of the instant writ petition shall not preclude or prejudice the petitioner in the proceedings so initiated by the Forest Department on the basis of the show cause notice dated 13/7/2026. It is further observed that in the circumstance, it is further observed that if in the meantime the petitioner had not submitted the show cause reply, the petitioner is granted 15 days from today to submit the show cause reply.
But my shop may be allowed to continue.
What?
My shop may be allowed to continue, my lord. They have, my lord, threatened me not to operate my shop, my lord. For this purpose, my lord, I am not operating it. That may be, my lord, allowed me. That may be allowed, my lord, to
How
operate.
can I allow it? You go there, file an application allowing you.
I have
If they
approached.
don't allow you, why should we look into it?
That is my prayer.
They have threatened, they have not given anything. Operate and file a petition to them.
My lord, that.
Now they are registered or not, you take it out. Next.
My lord.
Give the numbers of the other cases, we dismiss it on 14.
Actually, my lord, on the basis of that, they're threatening, my lord. I am not operating in, my lord. They have threatened if I operate, they will seal my shop, my lord. That's why taking away.
You file an application out there and say that you submit your reply. I've given you 15 days. Submit your reply. There, put it there also.
That observation, my lord, may be given.
Not necessary. Next.
Obliged.
What is this?
May it please your lordship. Lordship, we have come against the suspension of our trade license. The order of suspension is on the last page, lordship. And it has been done without giving us any opportunity of hearing, lordship.
Which one?
Page 77, lordship.
We issue notice.
Kindly stay it for the time being, lordship.
Why? You have no, wait. You have approached up to approach this court after 2 months.
No, lordship.
Yes, 36, 2026. We are
Lordship.
in the month of August.
1 month, lordship. However, in the meantime, we approached this honorable
Very
court in
well.
respect of.
You put the effect justice service upon them, then we'll consider. Not today.
But prima facie, lordship, there was no
There's no-
opportunity of hearing. lordship.
That you are saying.
Business
For
is
the
in-
purpose of suspension, it is not necessary. Is it required? For the purpose of suspension,
lordship,
notice is required.
provision is silent in respect of it. So
So
the principal
therefore,
court matters
whether
this
for
will
the purpose
automatically-
of suspension, for cancellation, definitely. But for suspension, is it required? Let us hear the other side.
Effectively, suspension is same, lordship, because. we
You
were able
could
to op-
wait, Mr. Counsel, for all this while. Why didn't you approach them immediately?
We came for anticipatory bail. We were granted the same by this honorable court, lordship.
So, anticipatory bail is same like trade
No,
license.
lordship, I'm saying that in the meantime, we were
Yeah,
under.
it's a serious allegation that you are involved in immoral activities there. Should we not look into that and give the opportunity to the other side? Tomorrow they will say that look here, forget about us. The court also does not give us an opportunity. You are asking a suspension to be suspended. Then, yes, Mr. Vatak. Don't get your stay rejected at your hands. Let us get it rejected at the hands of a senior counsel.
Lordship,
I am not going to stay it. I'll
Lordship.
give you an opportunity for affecting service within 7 days. We'll take it up. That
Lordship.
is the only way
Lordship.
out.
Lords,
Issue notice making it returnable. Why you are not making the municipal Gwalpara Municipal Board a party?
their party,
How?
Chairman was made a party, municipal board. was made a
municipal,
party.
municipal board ought to have been
Then
made a
How's
party.
it
I will-
maintainable the reputation?
I will correct it, your lordship, by filing,
How? By hand.
by IA, your lordship, by filing an IA, your
So
lordship.
as of now, municipal board is not a party, then how can we issue notice?
Ought to have been a party.
Then
I also did not look into it, your lordship.
issue notice making it returnable on 21st of August 2026. At the outset, Mr. S. Botaku, the learned senior counsel appearing on behalf of the petitioner, submitted there has been an inadvertent mistake in arraying the respondent number 3 as a party. The learned senior counsel submitted that the respondent number 3 ought to have been the Gwalpara Municipal Board represented by the chairman, Gwalpara, Assam, PIN 783101. So taking into account that it is a mistake committed by the council, this court, substitutes the respondent number 3 by the Gwalpara Municipal Board represented by Chairman Gwalpara, Assam, PIN 783101. The council appearing on behalf of the petitioner is directed to file an fresh memo of parties within 2 days before the registry of this court, and the registry on the basis thereof shall make necessary correction of the cause title and update the same in the CIS. So the council further is directed to rectify the name of the respondent number 3 in the memo parties in the cause title of the writ petition while serving. The case of the petitioner herein, Mr. A. Gogoi accepts notice on behalf of the respondent number 1 and 2. Extra copies of the writ petition be furnished by tomorrow. As regards the respondent number 3, the petitioner is directed to effect service by way of speed post. So the said step be taken during the course of the day. In addition to that, the petitioner is also granted the liberty to effect service upon the respondent number 3 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner hotel, namely Raj Mahal, was granted a trade license by the respondent number 3.
29
All of a sudden, on 30/6/2026, the petitioner's trade license was suspended by the chairman Gwalpara Municipal Board. That too without providing the petitioner an opportunity of hearing. Mr. S. Botaku, the learned senior counsel, further submitted that though the Gwalpara Municipal Board may have the power to suspend the trade license, but the same power of suspension can be exercised for a limited period of time pending a further action. Drawing the reference to the impugned order dated 30/6/2026, the learned senior counsel submitted that the suspension of the petitioner's trade license have been made indefinitely. Such course of action is not conceivable. The learned senior counsel therefore submitted that the impugned communication dated 30/6/2026 be stayed pending notice. This court have given an anxious consideration to the respective submissions, and it is the opinion of this court that without providing an opportunity to the respondent number 3 to place its case, a stay of the impugned order dated 30/6/2026 would not be in the interest of justice. Accordingly, this court shall consider on the next returnable date as to whether there is a requirement of passing any interim directions.
Lords. Your lordship is fixing it, your lordship is fixing a date, your lordship.
Yes, I have fixed it on 21/8.
Lords. Briefly, your lord.
My lord, the National Highway Department, my lord, initially, my lord, debarred me for 1 year. Then my registration as a contractor was also suspended. This has been interfered with by this honorable court, my lord. Based on the debarment by National Highway Department, my lord, now roads have also debarred me. Not only that, in the meantime, my lord, there were 2 tenders were issued where I emerged as L1. Now, those, my lord, has also been cancelled and it has been put to tender. So if your lordship would kindly have, my lord, page number 54, my lord.
H.
54, my lord. This is by Roads Department.
Yes.
With reference to the letter on the subject cited above, I am directed to convey approval of the government regarding Department of Rana Construction and Engineers Private Limited from participating in any ongoing or future tenders under Public Works Road Department, government for a period of 1 year with effect from the date of issuance of order dated 26/26 from the Office of the Chief Engineer, NH. This order has been interfered with. That lordships will get that order. 56, my lord.
This has been interfered with subsequently.
Yes. At page number 62, my lord. Sorry, 61. Huh? Oh, we part to go. Page 61, my lord, para 10. 8. In view of the above, this court is of the opinion that impugn action is not sustainable in law and is accordingly set aside. Respondent would, however, be at liberty to take appropriate action by strictly following the law. While doing so, the prescription laid down that such blacklisting can be for a limited period till rectification is done as provided in serial number 5 would also be taken into consideration. This is regarding, my lord, debarment order. Based on that, my lord, my registration was also cancelled by order dated 1/8/26. At this stage, Sri so-and-so for the petitioner submitted that in the meantime, a communication dated 1/8/26 has been issued, whereby in terms of the blacklisting order, registration of the petitioner has been suspended, and this fact has been brought on record by way of an additional affidavit.
So why didn't you bring this also there in that
No, Malad, this
proceeding?
is subsequent, my lord.
No.
After
This judgment
during
was,
pendency,
this judgment was passed on 3/8.
after filing of the writ petition. my lord.
But you brought 1/8. By way of paragraph number 9, you brought 1/8/2026 document.
Yes.
But why didn't you bring the 15/7/2026 document? The impugn order is 15/7/2026.
But one is national highway, other is roads.
That's the-
And my lord, most importantly, my lord, this cancellation of the tender has taken place on 7/8. That statement I have made. 5/8. Paragraph 15, my lord, that we could not annex. If your lordship would kindly come to paragraph 15, my lord. That the petitioner begs to state that it is an admitted fact that order dated 26/26 and the subsequent order issued by the chief engineer NH has already been interfered by this honorable court by judgment and order dated 3/8/26. The said judgment and order has attained finality, as till today no writ appeal has been filed by the respondents by questioning the legality and validity of the said judgment. As such, the same is binding upon the respondents, and any action taken by the respondents in terms of order dated 26/26 would amount to contempt of this honorable court. The respondent authorities, being well aware about the said admitted facts, have not taken any action for cancellation, withdrawal of letter dated 15/7/26. Rather, respondents have taken resort to the impugn action of cancellation of L1 bid of the petitioner in his meeting of the tender committee held on 5/8. As such, being left with no other option, the petitioner has decided to approach this court by way of the instant writ petition challenging so-and-so as indicated in letter dated so-and-so, issued by respondent, conveying government approval and minutes of the meeting with its so-and-so.
Why there are two judgments?
And page 63, we communicated these orders
Oh,
also.
the judgment.
On
Now
3/8
what do you want?
Milord, I want, Milord, the stay of these proceedings, Milord. Otherwise, they have issued a fresh tender also, Milord. I was, after evaluation of the financial bid, I was just to be L1 in respect of 2 works, Milord. Now they have issued a fresh tender following cancellation on 5/8.
Where is the tender committee's meeting 5/8?
That, Milord, that we have made a statement in paragraph 15 that they have not shared with us. That paragraph 15 which I have read, Milord. And Milord, retender has also been issued that we have filed an additional affidavit. Aise niki? I'm told, Milord, there is no link in the High Court server. Therefore, they could not send it, Milord. They have issued a,
Yes, Mr. B. Gogoi.
It will be on my lord Friday, but I will have the instruction. Because my lord, this particular department was interfered with in August. The impugn orders have been issued in July. So at that time, my lord, at least the department was
It's
there.
okay.
As on there, of course.
My question is it consequential to
yes.
the earlier debarment of 26?
Lots of.
26, it is consequential to 26. Then it cannot have, because otherwise, if you had a separate proceedings, which you
Yes.
had or not, it's the only question. We'll have it on Friday.
Yes.
And in the meantime, you get your instructions
Yes,
and
madam,
we
because-
dispose it of on Thursday.
Yes, well, it can be closed other
On Thursday.
Thursday, madam.
Milord, actually, Thursday, Friday, I'll not be. Could it be on Monday next month?
But I'm not staying it.
No, what I'm saying is, Milord,
I'm not staying it.
no,
Mr.
I'm not praying for a stay of the debarment order, Milord. At least they're regarding that tender. Milord.
I can't, because without stay of the debarment order, how is it possible?
Okay. Then let it come up on Monday next, Milord. As your lordship has rightly pointed out, Milord, because is a consequential to 26. Now 26 has been
In
interfered
fact,
with.
that is why I'm saying, you should have, you see, 1/8 you brought in. And accordingly, because of 1/8 being brought in, 1/8 was set aside by the learned coordinate bench. Why didn't you bring in 15/7 also? Because it was consequential, because that is the word
We
used.
basically challenged 26/6, Milord.
Understood. But after 26/6 came 1/8. 1/8 you brought it by way of an additional affidavit filed on 3/8. When that was, the learned coordinate bench set aside the consequential order also.
You
You notice making it returnable on 17th of August 2026. Can't your junior appear in this matter?
Milord,
Can't your junior appear in this matter and do the matter?
it can
Because
be.
it is a very simple matter.
Yes, yes.
And therefore, for you to fix it on Monday and thereby any other consequences befalls, then you are taking it at your own risk. Should you take it as a senior counsel?
No, actually, Milord, that 9th is the date for tender. That's why. 9th is the date for finalization of that tender, which we have today. It could not.
Understood. It is 9th. So therefore, your 9th is on Wednesday.
All right, lots will have it on Thursday.
Let us finish it up. Only
Thursday,
getting that
Thursday.
instruction if it is consequential, because there are
It is
two aspects.
consequential order
It
itself
is
says.
there are two aspects. If it is consequential, the consequence being over, nothing remains. The second is if it is not consequential, it has to be preceded by a show cause.
That is, which was not done.
None. So that is the only instruction. We finish it up. I think your juniors are capable of.
Yes. Thursday, Milord.
Issue notice making it returnable on 13th. 13th August 2026 at 2 p.m. Mr. B. Gogoi accepts notice on behalf
the
of the
respondent.
respondent numbers, all the
All the
respondents.
respondents.
Extra copies of the writ petition be served upon him during the course of the day. The petitioner primarily have challenged the order dated 15/7/2026 issued by the Deputy Secretary Works to the Government of Assam Public Works Department, whereby the petitioner was blacklisted for a period of 1 year on the basis of an order dated 26/2026 passed by the Chief Engineer PWD (NH Works) Assam. Mr. K. N. Chaudhary, the learned senior counsel, appearing on behalf of the petitioner, had submitted that the order on the basis of which the impugn order dated 15/7/2026 was passed have already been set aside by the learned coordinate bench of this court by the judgment and order dated 3/8/2026 passed in WPC number 3398/2026. He therefore submits that the impugn order dated 15/7/2026 cannot withstand the scrutiny of law. The learned senior counsel further submits that in the circumstance, the impugn order dated 15/7/2026 was not passed on the basis of the order dated 26/2026 by the Chief Engineer NH PWD (NH Works), then also the impugn order dated 15/7/2026 cannot withstand the scrutiny of law in view of the apparent violation to the principles of natural justice. The learned senior counsel submits that the writ petition, that the impugn order dated 15/7/2026 therefore is required to be stayed pending notice. It is the opinion of this court that an opportunity should be granted to the respondents so that before passing any interim order in the present facts, this court also takes note of that in the circumstance, the respondents also takes note of that there are various tender proceedings wherein the petitioner had duly submitted the bids and have also been considered as an L1. And on account of the order dated 15/7/2026, the petitioner's bids are likely to be cancelled.
It has already been bid. It has already been cancelled.
It has been cancelled. Which is also the subject matter of the present proceedings. Under such circumstances, this court therefore directs the PWD department, to place instructions on the next date as to whether the order dated 15/7/2026 impugned in the instant proceedings was consequential to the order dated 26/2026 issued by the Chief Engineer PWD NH Works. The PWD shall also provide instructions on the next date as to whether the impugn order dated 15/7/2026 was preceded by any show cause notice. It is the opinion of this court that the instant writ petition can be disposed of on the next date solely on the basis of the said instructions. And as such, The PWD shall provide the necessary instructions, failing which this court shall proceed with the adjudication, shall pass appropriate directions.
My lord, I have filed an additional affidavit that may be called for, my lord, where I have brought on record the new tender.
The addition, have you challenged the new tender?
Yes.
By how? Not by additional affidavit, Mr. Counsel. Not in this court. You cannot challenge new tender by way of an addition.
In the meantime, we'll bring on record.
That is your way, but challenging a tender, because if I allow you here, I could see that day I could see a case out where a challenge was made to a section 70 notice in a GST. Then an order is being challenged or under by way of an additional affidavit. That cannot be done. So I don't permit them. So I can't permit yours.
Anyway,
If
we'll
you have
bring it
to
on record.
What is this?
May I please, Lordship? Lordship, kindly pass on the matter for the time being, Lordship.
Why?
My senior is in next, Lordship. This guy.
Let's see whether he has a case or not. The senior appearing or not appearing makes no sense then. Yes, Mr. Sinha.
May it please your lordship, the respondents had issued a tender NIT in respect of slope stabilization.
What?
Slope stabilization of the hills.
Ah.
Your lordship will kindly come to page 40, page 39, sorry. Page 49, your lordship.
Take it. Thank you.
Okay. Then
This is,
where is the slope?
your lordship, the,
Arunachal Pradesh.
no, it starts from,
It's
Balipara, your
Arunachal.
lordship.
Oh. No, it's from hillside on road Balipara, Soridua, Tawang under so and so in the district of West Arunachal. Why are you here?
Because your lordship, the bid document says that the jurisdiction will be at Gauhati, at Assam.
Where?
Your lordship, yes, your lordship.
Where? Anyways, let us further proceed. What happened? You are RNB, submitted insurance security bond for AI in favor of so and so. Then what happened? Finding of technical shortfall. Not qualified as no similar work experience found. No shortfall to be asked. Yes. No similar works found.
No, your lordship, that's a precisely a wrong finding, I would say, your lordship. The reason is this. I had the experience of slope stabilization. They want two materials. That is rock, that is a rock protector with alarm and the articulation concrete block matrices. Now, these two are the materials which I need to procure from the manufacturer, your lordship. The main purpose is the slope stabilization. That I have an experience which I have annexed, your
Where is the
lordship.
term? Where?
Yes, your
Mr.
lordship.
Counsel, get your hard copy. You are not
No,
in a
no, your
position.
lordship, it is there.
No.
Your lordship will come to
Read it.
page
This is
75.
the matter next week.
Your lordship will
No,
come to
you are
page
not
75.
prepared. You are not prepared.
No.
You'll have it whenever you feel like. When will you be prepared with your matter? You are not in a position to find out. You are trying your luck before a court of this court. I can give
I'm
you
sorry, Your
this type of luxury on Tuesdays, on a Thursdays, not on a Monday or Wednesdays. or
Lordship, it is
Fridays.
at page 75, your lordship.
Can't help it. You are not in a position
I'm
to
prepared,
find
your
out.
lordship. I'll
Find it out. Last item of the day,
Yes, your lordship.
445.
Deeply.
What happened? There is one matter of that. What has happened? That council has not come. Or is it still stuck up out there in the ear? Itu the last item of the day. Item 3, last item of the day. 5 o'clock, 5:30.
Let's see, in this matter, let's see, we have submitted one affidavit.
You have an objection in the adjournment?
No, my lord, I was just, I thought that the matter will be, they will come at on time, my lord.
I've given time.
Yes.
Nothing is given. We'll have it at 4:45.
In
What
this
to do?
matter, let's see, we have filed one.
There is no urgency in that matter.
There is nothing, my lord. They, if you see, my lord, it's a case of putting a cost on them. Cost on them, I am telling you, lordship. There is an arbitration, my lord, that has been already, award has been passed. Award has been passed in arbitration manner. Now they want a restraining order from the Oil India. They want the Oil India should not give contract to us. And already the dispute between two private parties. It has been 11-6 has been filed, refer for arbitration, arbitral award has been passed, and they got a compensation of 1.5 crores. There was an agreement between both the parties, private parties, both us. 2023 to 2028.
The council, is your gowns very loose?
No, sir.
But what is this fashion? Button your cloth, button your coat. Yes, better off. You don't put these two together. That is not meant for that. Yes.
2023, my lord, there is an
Where
agreement
is
between.
your senior coming from?
From Horumuti.
There was no floods today.
There was waterlogging outside
No.
his area, lordship. Further,
No.
there was a
Who is
VIP
your
movement
senior?
outside in
Who is
Chanmari
your
also.
senior?
His counsel is Dikshit Govai, your lordship, who's
Huh?
going to argue. Dikshit Govai, who's
Where
going to
is?
argue. Just on his way, say, he already informed us that he's about to reach. Just at 11:45 may be listed. Lordship. Just last opportunity.
Doesn't go by 11:45.
Just request. I'm also helpless, your lordship. I'm also helpless without the presence of the senior.
We do want to, we'll take it up. Don't worry. We'll take it up. Last item of the day.
Yes, your lordship.
Last item of the day. And last item, I take it very leisurely. We'll impose cost also. Commensurating with the trouble which is being caused to the senior council.
I apologize on behalf of the senior lordship, please.
They'll give something like 15 lakhs. Nowadays, I've started giving in 10 lakhs. Thousands have no more. So lakhs starts from around 5 lakhs in this tender method.
That is understood.
Ask him
The
to also
senior may be given
ask
the
him also
opportunity to
get
explain.
his checkbook. He's on his way now. Ask him to get his checkbook also. Okay, okay. Last item of the day.
DP office.
See, we have.
Yes, what is this?
Lordship, in this matter, we have tendered one affidavit in opposition, but due to failure of link, lordship, it could not be. Lordship. Since morning, it is not there, lordship.
Nobody has appeared on behalf of the PHE.
Earlier, B. Gugui was there, lordship. I don't know.
Yes.
You have not filed your reply.
Lordship, today morning it was tendered to the section, but due to non-availability of link, Lordship, the copy has been served, Lordship. It was not.
It has been brought to the notice of this court that an affidavit has been, reply has been filed during the course, has been filed today by the petitioner. But tell me one thing, without a challenge to the order by filing a review,
Yes.
how can you raise these issues by way of a contempt, in a contempt? Have you read your file or not? What does it say?
Order does not contain a direction to verify, my lord. It only says pay. That
Understood.
problem is
So
there.
therefore, isn't it your requirement for filing a review?
Yes, my lord, the review.
Because without a review being done,
Yes, ma'am.
isn't it difficult?
Yes, ma'am. This is a
You
case
cannot
for
raise
review.
those issues here. Why don't you file a review?
We'll file a review, my lord.
What is he saying?
Yeah, we are contemplating a review, but before the review could be finalized, my lords, the contempt came to be filed.
Contempt filed in 2023 and you are still contemplating.
No, but at that point of time.
But then also you can file your review. Who has asked you not to file your review? This is a contempt of 2023. Then
I will file it.
take this stand which you have taken.
We'll file a review, madam, because verification is not there. That clause is not.
Both of you are seasoned counsels. Does it suit to make submissions to that effect that you were contemplating to file a review in 2022 and contempt was filed in 2023 and you are still contemplating till 2026? What a fantastic submission.
We have to go for a review, madam.
Huh? Then there's no way out.
Yes, madam. Yes.
So your therefore submission has to be that there are, upon verification, he is not entitled to. But on that day, the councils did not appear or could not submit. That is a different thing. But you need to bring it on by way of an affidavit, a review to that effect. The learned counsel appearing on behalf of the petitioner has submitted that the affidavit in reply has been filed. However, that same being not on record lists this matter along with the said affidavit in reply on 21st of August 2026. This court is not sitting out here as an advisory jurisdiction. But do something.
Obliged.
Obliged.
Yes, what is this?
Lordship, this is covered by your Lordship judgment and National Plasto Molding judgment.
And Pastor has gone for a 6.
Chips?
No more than.
No, Lordship, in the facts of the case, present case, Lordships, the supplier is still active.
So what?
The supplier is active. He has taken another GST number and the department has not gone to him. Lordship, he has,
Not necessarily. See, then recent order passed.
Lordship, that was from Bandari scrap traders from Gujarat.
No,
That was
no,
on
no.
constitutional validity, Lordships.
Counsel, the thing is like this. What had happened out there?
Lordships.
National Plasto was followed on the basis of the Delhi High Court.
Delhi High Court, question merchandising.
Delhi High Court judgment was for the Delhi VAT.
Lordships.
The Supreme Court in this order categorically says that the VAT and the GST are totally different aspects.
Lordships.
So therefore, the question of reading down section
16(2)(c).
Guys,
Lordship,
I, with due respect to the Supreme Court, I am in your favor. But the fact remains, as of now, till that judgment, and more particularly, when that matter from the Tripura High Court is still pending.
Lordship, so Lordship, that
they
is why
also had passed this order.
Lordship.
So therefore, the question of reading down, which was done by our High Court in National Plasto, cannot come into apply.
Lordship, now that judgment of the Supreme Court, which your Lordship is from Bandari scrap trader, it most respectfully I would submit, Lordship, it is not under Article 141. It cannot be stated to be a law of the land today. Because, Lordship, it was done at the notice stage, no respondents, and Tripura High Court, it's been recorded that Tripura High Court has given a finding. Lordship, similarly, 2 other High Courts, Patna High Court order is also before the Supreme Court, which is still pending. And those are on the Viris Lordships. In fact, Lordship, the Gujarat High Court, we were also there in for some of the petitioners before the Honorable Gujarat High Court. The Gujarat High Court order categorically stated we are not going to read down 16(2)(c, neither on the validity. However, for each of the particular cases, it has been now sent back to the respective bench to decide whether there is a connivance or not. That issue, because 16(2)(c validity, Lordship, of course, it has to be decided. I'm today my
Council, National Pasto had read down 16(2).
Lordship, National Plasto, Lordship, I have, Lordship.
Now then you see the judgment of the Supreme Court in it's a Constitution Bench judgment in what is that? It's a very difficult time to Punamere or something. Wherein it
Kunya Ahmed,
says-
Lordship, Kunya Ahmed.
No, not Kunya Ahmed. Wherein it says that when the order which has been by which the SLP has been dismissed by is given reasons, it is binding
That,
upon.
Lordship, that is Kunya Ahmed versus State of Kerala. I will, Lordship, Article 141, the doctrine of merger, though this, Lordship, it will not apply very humbly in the facts of the present case.
Right away, you go to the division bench. whether
Lordship,
it
let me
applies-
place, Lordships, another Supreme Court SLP of 17 July on the same issue. It traveled from Allahabad High Court. Department SLP was dismissed. I brought that order also.
The reasons.
Lordship, so that is why Article.
Here it is with reasons and categorically says
That-
that Delhi VAT would not apply.
Lordship, so I am not on Delhi VAT before your Lords. Lordship, I am not on Delhi VAT. Lordship, sees my prayers. What is my prayers, Lordships? Lordship,
Pastor, whatever it is of the
Lordship-
division bench is based upon Delhi VAT.
I am not, Lordship, for that moment, Lordship, let me not press National Plasto. Lordships, Lordships, let me not press National Plasto. Lordship, now, Lordship can have this compilation.
Well, don't know compilation.
No, Lordship, on GST aspect, what traveled up to Supreme Court. Lord, my case is, Lordships, my supplier has raised tax invoices to me. I have made him payment through banking channel. It is for rent of a particular space in a mall. Now, during the financial year 18-19, for some reason or not, he has not filed his returns properly. So that is not auto-reflected in my GSTR 2A. However, at that time, prior to 1st January 2022, reflection in 2A was not mandatory. That only came into effect by section 16(2)AA with effect from 1st January 22, when GSTR 2B was made mandatory. Prior to that, under section 59, I was entitled to avail ITC on self-assessment basis. And this, of course, traveled up to Supreme Court in Union of India versus Bharti Airtel, where the Supreme Court told, yes, 2A is only a facilitator, it's a tool. It cannot, you have to avail ITC basis self-assessment of your books of account. Those judgments are on record, I'll place before your Lords. Now, an audit of my books of account under section 65 was taken place by the state respondents. I put forward my entire input register. They made a comparison of input tax basis 2A and what I have availed in 3B. And they found out a difference. I replied to that audit memo, stated this reason is because
Well,
of...
before issue was Shokos.
Shoko, Lordship, it was...
Go there. Sorry.
Kindly takes the first order of this court, Lordship. Kindly.
Shoko, no, I am not interfering with the Shoko.
Lordship, it is returnable, Lordship, because respondent 4 was not...
Hard Mr. So-and-so. Okay, we do one thing. We vacate the interim order. Do whatever you feel like. Show cause notice, I don't entertain.
Lordship, kindly sees this, the first order of this one. The reasons, Lordship, why I was...
The reasons maybe. I'm not going to entertain.
Then Lordship, in that case, Lordship, just for you.
The council, no. Show cause notice.
Lordships, the show cause, Lordship, sees, let me place just once. They have not taken into account my replies.
I'm not concerned. You can very well again mention all these things and then they will take an action out there.
No.
Then they will initiate a...
Lordship, that was replied to them already, Lordships. Lordships, kindly takes the show cause, Lordships, at page number 43. 43 is the summary. The 46 onward it starts. Now, Lordship, kindly takes page 47. What is it? Lordships? Yes, Lordships. The by wide order dated 5/2/24. 5/2/24.
Mr. So-and-so.
Lordships, kindly.
No, sorry.
Lordships, kindly sees.
Sorry.
The show cause what they have written, lordships.
They have written head, whatever may be, head or tail, I'm not going to look into. Go there. Go there. Against this show cause, I'm not.
Lordships,
going-
give me one more opportunity, lordship, in that case. I will come some another day and I will place lordships regarding the.
I am vacating the interim order to do, you take after 1 year.
No, lordship, the show cause reasons, lordship. Then let it kindly seize the show cause.
Mr. Counsel, this is how I conduct my court. You have come from outside, I'm not
No,
bothered with that.
lordship, I have never placed that. Let's say.
Order, you appeal it before the division bench or go to the Supreme Court, wherever you go. But my question is, I am going to pass this order right now, whatever you do.
Lordship,
Take
just
your seat.
show cause not.
Heard Mr. Swanso, the learned counsel, appearing on behalf of the petitioner. Mr. Swanso appears on behalf of the respondent numbers 1, 2, and 3. Present petition has been filed by the petitioner. Assailing the show cause notice dated 11/1/2024, issued by the respondent number 2 under section 73 (1) of the Assam Goods and Service Tax Act 2017. It is the specific case of the petitioner that the issuance of the said show cause notice would not have been done by the respondent authorities. Respondent number 2, without taking into consideration that the petitioner had duly paid the taxes to the seller, to the purchaser of the services.
Seller
Seller of the seller of the goods.
Services, Lord. In my case, it is service. Because it was rent.
They cannot be a seller of the, you have.
I was paying rent to the supplier of services, lordship.
So therefore, that is it. You are.
I am the purchaser, he is the seller.
You have purchased from
A particular supplier. He is giving me rental services.
without taking into consideration that the petitioner have duly paid the GST to the supplier of the services to the petitioner. And on account of rental services to the petitioner, and on account of the supplier, on account of the supplier of the rental services having not submitted the returns or inadequately submitted the returns, the initiation of proceedings under section 73(1) of the Act of 2017 requires to be interfered with. This court have duly considered the submission on behalf of the petitioner who have relied upon the various judgments of the Supreme Court as well as the documents evidencing that the petitioner had paid the dues to the respondent to its supplier. to the respondent number 4.
4, Lorships.
To the respondent number 4. First. The question as to whether the petitioner had made payments to the respondent number 4 or and as to whether the respondent number 4 had submitted the returns of the have duly submitted the returns are questions of facts. Now, are questions which do not take away which do not are questions of facts which can be very well adjudicated by the proper officer. The law referred to by the learned counsel appearing on behalf of the petitioner as settled by the Supreme Court can also be placed by the petitioner by submitting a show cause reply to the show cause notice, impugned show cause notice. This court also takes note of that there is no jurisdictional error committed by the respondent number 2 in issuance of the said show cause notice. Under such circumstances, this court is therefore not inclined to entertain the instant writ petition. This court inquired with the learned counsel appearing on behalf of the petitioner as to whether you'd like to file a reply,
Yes, Lordships, I'll have to file.
whether the petitioner had submitted the reply to the show cause notice. The learned counsel submitted that the petitioner have not submitted the reply to the show cause notice in view of the interim order filing of the present writ petition and the interim order passed by the learned coordinate bench of this court in the order dated 5/2/2024. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. This court finds no jurisdictional error committed by the respondent number 2 in issuance of the show cause notice dated 11/1/2024, bearing reference number ZD1801240177866B. Number 2. Taking into account that in view of the present proceedings and the stay so granted by the learned coordinate bench, the petitioner had not submitted the reply. This court grants the petitioner a period of 30 days from today to submit reply to the said show cause notice, impugned show cause notice dated 11/1/2024. In the said reply to the said show cause notice, the petitioner would be at liberty to raise all the issues which have been raised in the present proceedings. Number, taking into account that this court had stayed the show cause notice dated 11/1/2024, And further, this court have now permitted the petitioner to submit a reply within 30 days. This court is of the opinion that the period from 12/1/2024 till date should be excluded while computing the period of limitation in terms with section 7310 of the Assam Goods and Service Tax Act 2017. Accordingly, this court observes and directs that the period from 12/1/2024 till date be excluded while computing the period of limitation in as regards passing of an order under section 73(9) as regards the limitation as mentioned in section 73(10) of the Act of Trust. Therefore, interim order stands vacated. Much.
27, Lordship, in this contempt matter, Lordship.
And there are three parts of this order. My lords. One, to pay his principal. Principal has been paid. Second, my lord, to deposit a cost of 10,000 to the bar, the legal services that has been paid. And my lord, the interest part is in process. FS has been asked.
You have paid 22 lakhs.
Principal amount has been refunded, Lordship, but the interest amount remains to be paid, Lordship.
Interest is under process, my lords.
And also, Lordship,
Interest is under process. FS has been asked for, my lords. Financial sanction. Cost paid, my lords. Cost paid. 10,000 has been paid.
Now what is this? Interest 4,93,000.
That printout, if like lordship is holding, it's that net amount which has been debited to the account of the petitioner, 22 lakhs something, my lords. And that other communication lordship is holding, my lords, it's for FS for like that interest amount, my lords.
When are you paying it?
My lords, it's under process. Cost also paid, my lords.
This is an application filed for alleging willful and deliberate violation to the judgment and order dated 18/6/2024 passed in WBC number 4853/2023, whereby there was a direction issued upon the respondent number 2 and 3 therein that the amount of rupees 22,12,375 be paid to the petitioner within a period of 1 month from the date of the said order, said judgment and order, and further, the petitioner would be entitled to interest at a rate of 6% per annum with effect from the date of deposit of the said amount by the petitioner with the Forest Department till final repayment of the principal amount. In addition to that, there was also a direction upon the Divisional Forest Officer, Jorhat Division, to pay a cost of rupees 10,000 within a period of 1 month from the date of the said judgment and order. In compliance to the said order, the amount of rupees 22,12,375 have already been credited to the account of the petitioner on 12/3/2026. Insofar as the cost is concerned, it is submitted by Mr. D. Gogoi appearing on behalf of the respondents that the said amount have also been deposited before the registry of this court. Further to that, as regards the interest, which is quantified at rupees 4,93,138, this financial sanction have been sought for and would be paid immediately upon receiving the financial sanction. Taking into account the above, list this matter on 18th of September 2026. In the meantime, the respondent shall take due steps for clearance of payment of the said amount of rupees 4,93,138, which is the amount payable to the petitioner on account of the interest. The instructions which have been placed by Mr. D. Gogoi, the learned counsel appearing on behalf of the respondent, are kept on record and marked with the letter X and Y.
Obliged.
Here's what has happened.
Respondent number 4 and 5 were newly, may I please, Lordship? Lordship, for respondent number 4 and 5, Lordship, newly impleted, Lordship. Newly impleted, Lordship, in this matter, Lordship. Some time may be granted so that we can take the instruction.
Final opportunity.
Sure.
The respondent number 4 and 5 is granted another opportunity to bring on record its stand by filing the affidavits to establish this matter on 25th of September 2026. In the meantime, the respondent numbers 4 and 5 shall bring on record its stand by filing the affidavits on or before 22nd of September 2026.
May it please your lordship. Lordship, as per the direction, my lord, I have received a substantial portion of the amount, my lord. Just 1,43,000 is left to be paid by them, my lord. Now they have come with a plea that after that direction, there were some defects in the deep tube well, my lord. So they had to engage third party in order to clear the defects. So they are withholding the payments, my lord. No, but otherwise the order was sort of consensual order, my lord. The order, my lord, finds at page 15, my lord. They have themselves admitted that they are yet to pay the 30% of the balance payment. So they were directed to be paid within a period of 3 months, my lord. So after the contempt was filed, my lord, they have released some payment of rupees around 2,70,000, my lord.
Amount has not been quantified.
Amount in para 2, my lord. By way of this writ petition under Article 226 of the Constitution, the petitioner is seeking direction.
Understood, but what is, which is equivalent to 70%?
Yes.
Despite 7, the remaining 30% have not been paid.
Yes, ma'am.
The present petition has been filed. So there was an order that in view of the merit, so and so is of the opinion that the instant writ petition can be disposed of by directing the respondents to release the balance 30% of the remaining payment claimed by the petitioner in accordance with law within a period of 3 months from the date of receipt. In accordance with law means as per whether you are entitled or not. You have got that money. Where is that order?
My
They
lord,
have given
no,
that
yes,
they
I
are
have filed my affidavit, my lord. Yes, I have also accepted, agreed to that. Thing is that during the defect liability period, my lord, the pump got damaged. So their notice was sent to him to repair it. He didn't repair it and third party was engaged and third party have to be paid that amount. So that amount has been deducted.
Where? How much amount?
My lord, it's 99,000, my lord, paragraph number 5. And the notice is in page number 31.
Have to be rectified by engaging the third party to rectify the defect at so and so. As such, the amount due to has to be adjusted. Therefore, the balance amount due to the petitioner for Warner AI is rupees so and so. As regards project property, amount of rupees so and so, and there has already recommended release and the amount is.
There are two projects, my lord, 40.
So it is only for 99,000.
Yes, 99,000 we have to pay to the third party.
It is only 99,000 he has not got.
Yes, my lord, but it's around 1,40,000, man. As per my
We are
calculation.
not going to look into that.
Okay.
The direction was to pay in accordance with law. If there is any rectification, this will become within the ambit. So therefore, in view of that, if you want to challenge that, you challenge it before the civil court, not here. Now, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent number
1 and 2.
1?
1 and 2.
1 and 2. Is an application filed for alleging willful and deliberate violation to the order dated
13/6/25.
13/6/2025 passed in WPC number 1872/2025, whereby there was a direction issued upon the respondent authority to release the remaining balance amount of 30% claimed by the petitioner in accordance with law within a period of 3 months from the date of receipt of a certified copy of the said order. It is seen that pursuant to the filing of the instant affidavit petition application, an affidavit has been filed by the respondent number 1, wherein it is mentioned that an amount of rupees 99,000 has been withheld from the dues payable to the petitioner on account of the
Repair of the pump.
on account of the rectification which had to be carried out during the defect liability period through a third party, inasmuch as the petitioner did not, in spite of requests, carry out the rectification. Carry out.
Yes, with number 31, I have anything.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, on the other hand, submits that the amount which have been deducted is an amount approximately 1,40,000 and not 99,000. This court duly takes note of that the learned coordinate bench of this court in the order dated 13/6/2025 passed in WPC number so-and-so had directed the respondents to make payment of 30% of the remaining dues in accordance with law. In other words, the said direction to pay 30% of the dues was coupled with a direction that the said payment shall be made as per the entitlement of the petitioner. If it is the opinion of this court that if the petitioner has to contest on as to whether the deduction should have been 99,000 or 1,40,000, it is the civil court which can adjudicate the same. This court, in exercise of the contempt jurisdiction, cannot adjudicate the same. Accordingly, in view of the stand taken by the respondents in the affidavit, this court drops the present contempt proceedings. Liberty given to the petitioner, if so advised, to approach the civil court if permissible under law. What is this?
It's contempt, my lord. We have taken the steps, my lord. They are not appearing, my lord. Till the last
Who?
PHC, my lord.
PHE.
Name not shown. Cause list doesn't reflect our names, my lord.
It won't, because it's a contempt. The contemptor is not appearing. Service is complete.
My lords, most of the
So
matters.
we therefore ask you I request you to take instructions as to why the order dated 29/8/2025 has not been complied with. Give me a copy.
Furnish the copy.
There is a direction to verify the entitlement and to release the amount within a period of 2 months thereafter.
Yes.
You could. There is an application filed alleging willful and deliberate violation to the order dated 29/8/2025 passed in WPC number 2682/2025, whereby there was a direction issued upon the respondent chief engineer water PhD to verify the claim of the petitioner within 1 month from the date of the said order. And further, in the event the petitioner was found entitled to, the same be released within a further period of 2 months thereafter. It is the case of the petitioner that in spite of the certified copy of the said order dated 29/8/2025 in WPC number 2682/2025 having been served upon the respondent, neither any verification has been carried out nor any payment has been made as directed. It is under such circumstances the present contempt application has been filed. This court duly takes note of that the service upon the respondent number Sole respondent. na?
Sole respondent.
Sole respondent is complete. However, the sole respondent have not put in the appearance. Accordingly, this court have therefore requested Mr. D. Gogoi, the learned standing counsel of the PHE, ED, to obtain instructions from the respondent as to whether the order dated so-and-so passed in WPC number so-and-so have been complied with. He shall also obtain instruction as to the reasons and complied with. Full stop. A copy of the instant contempt application be served upon him by the learned counsel appearing on behalf of the petitioner, so that Mr. D. Gogoi, the learned counsel for standing counsel of the PHED, can obtain the necessary instructions. The name of Mr. D. Gogoi be reflected in the cause list. During the course of the day, you serve.
Just serve it.
Oh, I've not fixed it, no. This matter again on 14th of September 2026 for placing the instructions.
May I request your lordship? Lordship, as per the last order, the service is complete in respect of respondent number 4 and 5. And on the last occasion, the respondent number 4 has also entered his appearance and was supposed to file affidavit. Let it become for admission.
Four need. Well, that's the
Yes. What is this? You have not filed
the
your reply?
debarment, my lords, has been subsequently it has been withdrawn, my lords. The blacklist has been withdrawn.
During the pendency of the
And otherwise, my lord, instructions are awaited.
After passing of the interim order by this court, they have issued a department notice.
This has been withdrawn, my lord.
Which was withdrawn. Again, that I have we have
No,
had-
not on that. My question is what he's not challenging the debarment notice here.
No, Lord.
Why haven't you filed your reply in spite
Well,
of that?
instructions are awaited, my lords.
Okay.
Short accommodation, my lords, for today.
The repetition notice in the instant repetition was issued on 16/6/2026. Thereby extending the interim order which was passed on 5/6/2026. In spite of there being an interim order, the respondents in the APDCL have not chosen to file a reply. Mr. D. Gogoi, the learned standing counsel of the APDCL, submits that a further opportunity may be granted to the respondents to bring on record their stand by filing their reply. Who are you?
Appearing for respondent number 4,
Who is that?
Sir, Electrification Corporation Private Limited. I have received my instruction by affidavit.
Mr. So-and-so appears on behalf of the respondent number 4 and submits that the respondent number 4 would also like to file their reply. Considering the above, as no urgency has been shown by the respondents in bringing on record their stand, list this matter on 6th of November 2026.
Lordship, can it be short date, Lordship?
Why?
Because my vendor approval has not been done by the APDCL, which is pending. Lordship, my vendor approval license is pending before the APDCL authority, which has not been approved till now due to the pendency of the present writ petition, Lordship.
What is your prayer?
Lordship. Lordship, page 25.
The blacklisting has been withdrawn.
Withdrawn, ma'am.
Yes.
Where is your ear?
Lordship, page 25, clause C of my prayer, and as to why the renewal of vendor license shall not be approved by the respondent number 3. My application for renewal of vendor license has already been pending before the respondent.
Renewal only will be considered, not approved.
Due to the present pendency of the writ petition.
You need to consider for approval.
Removal from proposed vendor list. What are you challenging here?
Lordship, so cause notice.
Which one?
Lordship, at annexer 11 and 13. Page.
আমাকে mark করে দিন next level.
Page 57 as well as annexer 13, page 60.
You have submitted your reply. Then
Then they,
second proposed notice given what?
yes.
So against the second proposed notice, have you submitted your reply?
Yes, Lordship, at page 61. We have replied to that in
No,
addition.
you have not submitted your reply.
Actually, this
You are
is not
requesting for time.
requesting time to, and we have also asked them to furnish the complete test report to us, but they failed to furnish the same.
Yes. Why haven't you provided that? This is the only matter. Why should we keep these type of matters pending? If you look at the page 61,
My lord, will provide that.
you're having it this week,
My lord,
Friday. Get your reports.
my lord.
Can it be on 17, Lordship?
No. Friday, you get the laboratory test report, we hand it over, then ask him to file his reply, and you do whatever you feel
My
like. Why should we look into all
Listen.
these things? Unless you're filing an affidavit makes no sense. You can, he's only asking that.
My lord, the report. my lord.
So submit,
provide.
let him submit his reply to you. Take a decision what you feel like, then we see him again
My lord.
running the corridors of the court.
Lordship, they,
Nothing more. Matter is over then. It's a small matter. The matter is only to that effect. Yes, Mr. Bidas.
Next week.
You get hold of that laboratory test reports
Lord.
on Friday. We hand it over to him. Ask him to submit his reply matter over. Then you take a decision.
Yeah.
Lordship, the test was conducted in my absence and the sample was taken.
Now you did not raise that issue in your reply. What you are asking? You are asking kindly provide me, then we can. That is the reason you are coming before this court. You are coming before this court. Why? Then look here. I have been asking them for the laboratory test report. They are not. How can I file a proper reply? This is your submission.
Lordship, para 17 of my.
Forget about 17. Come to page 61.
Yes, I have seen.
Don't raise other issues. This is the only issue. 61. Go there. This court is not going to look. If anything happens, we are there. If you are blacklisted, we will look into it. I'll also mention you submit your reply, they will give you a proper hearing and thereupon decide. That's all. You get that order. You have come because of that. Look, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. D. Gogoi appears on behalf of the APDCL. Mr. So-and-so appears for the respondent number 4. The issue involved in the present proceedings is the grievance of the petitioner that a second show cause notice have been issued to the petitioner asking the petitioner to submit a reply within 7 days and not considering the petitioner's request for providing the test reports of both laboratory tests in which samples of 11 kb MVCC were reported to have failed. It is the specific case of the petitioner that in view of non-availability of the said, not furnishing of the laboratory test reports, the petitioner would not be able to submit an effective reply. Mr. D. Gogoi, the learned counsel who appears on behalf of the appeal, shall produce the laboratory test report if it exists on 14/8/2026 list recording.
Lordship, there is an interim order which may continue.
Interim order passed earlier shall continue till the next.
But I seek a lot of indulgence in a matter. Item 3 motion, my lords. I will like to seek to withdraw. I was
445.
my lords,
445.
my lords. I was late because of my scooty, my lords. So
Your junior has said floods. Means
flood,
today there
my lords,
was no
exactly.
flood.
No, there was flood, my lords. I came by scooty, it broke down, my lords.
We'll take it up at the last item. We are fixing.
We'll withdraw, my lords. We'll withdraw.
You want to withdraw?
Yes.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits
If it is
that he has instructions to withdraw the instant writ petition. Mr. D. Das was appearing for whom?
For respondent four.
as such, no instructions.
Appears on behalf of the respondent numbers
2 and 3, Lordship.
2 and 3. And Mr. So-and-so appears, Mr. D. Das, the learned senior counsel assisted by so-and-so appears for respondent number 4. Taking into account the above, the prayer made by the learned counsel for the petitioner, the writ petition stands dismissed on withdrawal.
There were no instructions to withdraw. They were still disputing with me. I counseled them that your matter has no merit. It's better to be withdrawn. My lord will kindly reflect that thing. Otherwise, they will also again trouble me. My lord. That no instructions are also there. But going to the brief, I went to take
You
him to
cannot
the
do that.
my lords.
Mr. Digo,
My lords, I understand. I understand. I just tried.
It has to be, withdraw has to be on instructions.
My lords, withdrawing my lords. No merit in this.
Because if he doesn't do so, I dismiss it.
Dismiss, my lords. My little dismiss, my lords. My lords.
That, for that, we have to hear at 4:45.
No, my lords, simply said, done, my lords. That'll do, my lords.
Which one?
Lordship just passed it order. My lord, that'll do.
Withdrawal on
Yes.
instructions.
Okay.
May I please, your lordship?
Oh, yes, Mr. Sen, what is
My
this?
lord, in this case, my lord,
There
this,
are
this
papers that
report,
has been allotted to the respondent as per the protection.
office note dated 8/6/8, my lord.
Yes. Respondent number 5, service.
Lord, as per office note, my lord, the service report is awaited.
It's okay.
Flagged, my lord.
You do one thing. You give him an extra copy, he will serve it. This is under Rongia.
My lord.
Yeah. Give him, through the office of the respondent number 4, you get it served. It is seen that the service upon the respondent number 5 is not complete in spite of steps being taken. Taking into account that the respondent number 5 is carrying out the fair price shop within the jurisdiction of the respondent number 4. This court directs the learned counsel appearing on behalf of the petitioner to serve an extra copy to Mr. M. Setia, the learned government counsel, who appears on behalf of the respondent numbers 1 to 4. Mr. M. Setia, the respondent number 4 shall thereupon effect service upon the respondent number 5 and place an instruction to Mr. M. Setia, the learned government counsel, about the service. This matter again on 28th of September 2026. You serve it today. My extra copy. During the course of the day will be.
Their grievances is against the private party actually. Their grievances is against the private party. Main grievances. It's a purely private dispute. We have handed over the fishery and we have nothing to do with it. We are only concerned with the revenue.
None appears on behalf of the petitioner on call. It is also seen that the service upon the respondent number 7 is not complete. Under such circumstances, the petition counsel for the petitioner is directed to effect service upon the respondent number 7 by way of speed post. Again, within 5 days. Is the matter upon the service upon the respondent number 7 being complete.
Obliged.
Your Lordship. Lordship, as per the office note dated 15/7/26, Lordship, the item, the notice is supposed to be delivered, Lordship. For on respondent number 2, Lordship.
What is your case?
Lordship, the case is against the order of the Industrial Tribunal, Dibrugarh, dated 15/6/2026, Lordship. In fact, Lordship, you have dealt with this matter earlier also, Lordship.
Who?
Lordship, this bench only.
What? Where?
On that, Lordship, this entire matter is regarding the applicability of section 18 of the Industrial Disputes Act regarding to the disbursement of pensionary benefits, Lordship. However, Lordship, during a earlier writ petition in 5586 of 21, Lordship.
I directed for disposal.
Yes, Lordship.
And what happened?
Now, the Learned Industrial Tribunal in this order has two aspects, Lordship. They have, the Industrial Tribunal has framed, is willing to frame a preliminary issue regarding the ownership of Mahakali Tea Estate. And another aspect is the applicability of IRC 2025, IRC 2020 in respect of this dispute. Lordship.
Again, you have come against the preliminary issue.
Lordship, yes, Lordship.
Why?
Because, Lordship, the preliminary issue, Lordship, the Industrial Tribunal is trying to frame a new preliminary issue regarding the ownership of Mahakali Tea Estate, Lordship. That aspect was already considered in 2021 itself, Lordship. Fight order dated 19/9/2022, Lordship. Lordship, if Lordship will have a look at page 341, Lordship, that aspect has already been clarified by His Learned High Court, Lordship. We are not going for a new preliminary issue, Lordship. We are willing to proceed with the adjudication, Lordship. But the industrial tribunal is trying to frame a new preliminary issue, Lordship, which is beyond its power, Lordship.
What is the reference?
Reference is 2 of 2021, Lordship.
No,
The notification, if Lordship is seeking for the notification, Lordship, notification is on page 97, Lordship.
Whether the management of Mahakal State is justified in notifying notify the notice under section so and so forth. If not, whether it should. Why is it required to make Lakshmi Tea State or McLeod Russell a party to the proceeding?
That is the case, Lordship. It's not required. In fact, Lordship, if you have a look at page 341, Lordship, the earlier bench of the Gauhati High Court has clarified this matter, Lordship. The bench had directed the industrial tribunal to proceed regarding the applicability of section 18, Lordship. Then there is, in the order, there was a slight mistake, Lordship, regarding the applicability of agreement dated 1969. In our case, it was 1990. That matter was clarified by your Lordship regarding to proceed with the adjudication, dispose of the matter on merits. After that, Lordship, what is the need for this preliminary issue and applicability of IRC Industrial Relations Code? It's beyond my understanding, Lordship. And even, Lordship.
Yes, government. What do you say?
We have no instruction.
What? No, my question is, when the reference is for management of Mahakal State, can the court go into the issue as to who is the owner? of Mahakalti state?
No, man.
The scope of the reference is whether the management of Mahakalti state is justified to notify the notice under section so and so for changing the existing service condition and discontinuance of the pensionary benefit enjoyed by the retired staff employees so and so. If not, whether the employees of can enjoy the existing pension as per the agreement dated so and so. If not, what are the other reliefs entitled in lieu thereof? This is the scope of the reference.
My lord.
If the reference has been made to that effect, can the labor court decide who is the owner?
No, man.
Huh?
No, that is not the reference, man.
That's not the reference.
Yes, man. Reference is clear in 97 page, man.
I would have set aside this type of orders, but the fact remains the other side is not served. Why you are not serving it by way of dusty? Serve it by way of dusty.
Lordship.
It is seen that a service upon the respondent number 2 is yet to be completed.
This notice is shown to be delivered, Lordship. As per the postal receipt, the notice is shown to be delivered as delivered, Lordship.
But anyway, it is seen that from the office note dated 5/8/2026 that the service upon the respondent number 2 have been shown to have been delivered. Be that as it may, as no one has appeared on behalf of the respondent number 2, this court directs the petitioner to effect service upon the respondent number 2 by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. Is the matter again on 23rd of September 2026. Interim order passed earlier shall stands extended till the next.
As per my lord, order dated my lord 22/7/2026, my lord, notice was issued and steps was taken. And as per office note dated my lord 5/8/2020, service is not completed, awaiting service report. My lord.
Lordship, we have received the instruction, Lordship, we will file an affidavit in this case, Lordship.
What is this?
This is my lord settlement of market, my lord.
Respondent number 7 is disqualified.
Disqualified, my lord.
Why?
Why my page, my lord, 25, my lord. And except 2, my lord.
Why?
Serial number 3, my lord. Page 25, serial number 3, name is Pradip Dole. He was a disqualified, my lord.
Where?
Page 25, my lord.
Where's the original? This one?
My lord.
Huh? Where's the original?
Original turn into page.
This is a typed copy.
Yes, but 27 turn into page 20.
Nobody can
30,
read
30,
anything.
30, 30, page 30. Pradip Dole, my lord. That's one number 7, my lord.
Why?
My lord.
You are, what's your name?
My name is, my lord, Mukta Chongkang. I am in the third highest bidder, my lord. And
What about 2 and 1?
2 and 1, my lord, he is directed to deposit the money, but he did not do it. They did not do it, my lord. Page 25, your lordship, I am reading, my lord. That. May I read, my lord? In page 25. in person to NIT dated so and resolution adopted by the Revenue Resource Settlement Committee has been prepared
Yes,
against.
you are appearing for whom?
Respond number 4,
What is that?
standing council, missing autonomous council.
Huh? Oh, missing.
Autonomous council.
Okay. This has been done by missing.
Missing autonomous.
And tribal affairs, what do you have to say?
My lord, no, this is the King's thing only, they will do it, my lord. But my lord, I have gone through their instruction, yes, my lord. It says that no, they did not instruct anybody to collect money, neither in writing nor verbally. That is there in the instruction. Yes, I have. Let them file affidavit, my lord.
Ms. So-and-so, who appears on behalf of the respondent number 4, submits that the affidavit, that some time is required to submit the affidavit, required for filing the affidavit. So it is also noticed that the service upon the respondent number 5, 6, and 7 is not complete. Can have effect by Dusty.
My lord, I allow.
The petitioner is granted the liberty to effect service upon the respondent numbers 5, 6, and 7 by way of Dusty. Routed to the registry of this court and file an affidavit of service on or before the next date. This matter again on 9th of September 2026. In the meantime, the affidavit be filed on behalf of the respondents. Respondent number 4. So in addition to that, the other private respondents would also be at liberty to bring on record their stand. So the interim order, which was passed on 22/7/2026, stands extended till the next date.
Give me your first.
May I please, Your Lordship?
Yes.
Lordship, we have forwarded to the finance department, your lordship, the proposal for the financial sanction. It's pending in the financial department. Once the FOC is received, we'll disburse the amount, your lordship.
You are the social justice.
Social justice, your lordship.
Mister, you
Yeah,
are standing counsel.
On behalf of RM.
Mr. Counsel, you have a big problem. You are not understanding it. You cannot make that submission. If you make that submission out here, if I record it by somebody, it has no effect.
Lordship.
A standing counsel is being authorized by the department. Can anybody else appear? Because what
My
you
name may be
say
reflected as-
today, if I put it, it will have an impact upon you. You are no business, no person. You are not understanding that. It's a very serious consequences.
Lordship.
Where is the counsel, Ardeka?
Lordship, P. Chakraborty is there. She's available.
Ask her to come.
Sure.
If she makes a submission, it will be okay, na?
Lordship.
You are for finance? Why you are not removing?
If I can get a copy of this proposal, I can find out as to what is the status of the financial proposal that has been sent by the social welfare department.
Show me that.
It's a snapshot. Lordship.
I'll put Miss P. Chakraborty's name.
Lordship.
Is there in the court.
Yes, your lordship.
Ms. P. Chakraborty, the learned standing counsel of the Social Justice and Empowerment Department, has submitted that the FOC proposal of rupees 17.06 lakhs, which is payable to the petitioner, have been forwarded to the Finance Department on 17/7/2026. Mr. M. Bhuya, who appears on behalf of the Finance Department, submits that he would obtain instructions in that regard and place it before this court. This matter again on 16th of September 2026. In the meantime, the Finance Department of the Government of Assam shall do the needful for clearing the aforesaid, so that the petitioner can be disbursed the amount. So an update be placed before this court on the next date. What are these?
These are listed as per order dated 15/5/2026, madam.
Meeting has been held, my lord, in the conference hall of, my lord, in presence of additional chief secretary and other officers, my lord, regarding the, my lord, bills of the petitioners, my lord. Because earlier it was VAT, my lord, then again now they have to, my lord, calculate as per GST, my lord. The meeting has been held, lordship, may I please to peruse the, my lord, minutes of the. They are asking for, my lord, 2 months time.
For releasing the amount.
My lord, because now again they will have to, for, my lord, it is from the, I have received from, my lord, police department, because now police is to submit the, my lord, bill again, my lord.
In pursuance to the order passed by this court on 15/5/2026, Ms. Yudas, the learned additional senior government advocate, have placed before this court the minutes of the meeting held in the conference room of the additional chief secretary, Home and Political Department,
On 29 July 2026.
on 29th of July 2026. This meeting was held. It was decided in the it was observed in the same meeting that the revised estimates submitted to the department did not contain the requisite details, calculation sheets and supporting documents. Accordingly, the revised estimates were called for, incorporating the change in the GST and resubmitted with the SSFC checklist, certificates and other required documents, as the revised proposals are required to be placed before the Special Standing Finance Committee for consideration and approval. The managing director of the APHC Limited was also requested to make early submission of the same within 15 days. 15 days not over.
Today it has not elapsed, my lord. Today is the 13th day.
Taking into account that the respondents, the copy of the said minutes of the meeting, taking into account the above, this court adjourns the matter to be listed again on 12th of October 2026. In the meantime, the respondent authorities are directed to expedite the process so that the petitioner are provided their entitlement at an early date.
Deeply obliged.
May it please your lordship.
May it please your lordship. Lordship, my senior legs on another court. Let the matter come up after some time.
Yes, Mr.
Yeah, we have
Adoi,
sentenced the award passed by the London Industrial Tribunal, but the petitioners were terminated from service. Their workman of tea garden, and after termination, dispute was raised, but it was not referred. Accordingly, under section 2A, application was filed, and in that, my lord, application was dismissed, termination was upheld. Against that, we are before your lordship.
Where put inside you were in there was a conviction.
No, my lord, that was acquittal. After acquittal, we preferred this. But
It's a case of theft
theft. But we were acquitted
on
and,
benefit of doubt.
benefit of doubt. Let me tell you.
Now, on the basis thereof, you are asking for that you should be
No, that-
reinstated.
That I am not claiming. My case is on merit, my lord, as the allegation of misconduct was not proved against me in a domestic inquiry. So we are entitled to have the reinstatement, because that if it is not proved in the domestic inquiry, our misconduct, the theft was not proved in the domestic inquiry itself. So
This
we did-
matter came up before me earlier. Then,
without proving that, my lord, we are being dismissed.
but then why were you terminated?
We were terminated, my lord, the inquiry officers
Has
report
the records come?
records have come.
Taking into account that the records are available. No, this is an application. This is the present with petition has been filed assailing the award dated 28/10/2021 passed by the learned presiding officer Labor Court Dibrugarh in ID case number ID or reference case? ID
Not
case
reference,
number
ID.
11/2017. It is also seen that the records of the learned Labor Court Dibrugarh have already been requisitioned and are available. Accordingly, this court admits the instant writ petition, thereby issuing a rule there would be no necessity of serving extra copies upon the respondents, taking into account that they have already received they were already served copies of the writ petition. List this matter on 5th of November 2026 for hearing. Where is Mr. S. Hawk? Isn't he? He's the counsel or there is somebody else?
He is the counsel.
Huh?
He is the.
No. This is by some N. Bormon. Seeing the name of the petitioner, I saw that Mr. S. Hawk.
Regarding non-payment method, can it be on Friday? I will place the admissible report.
What? Non-payment?
Yes, ma'am.
PWD?
PWD.
The PWD, you verify pay as per year and pay as per Tamsir Ali. What is there?
Not,
Why should I, your affidavit, if you file that he is entitled, then also I can't allow.
not, sir.
To do that. Allow the repetition to the effect PWD order. 1 month verification, pay as per Tamsir Ali. Who are you?
I'm for respondent number 6. After the video.
Huh?
I'm appealing for respondent number 6.
Why?
My lord, the work was done for us. Where the Bhaktadev University and our feeling was there.
Payment is to be made by whom? Mr. Patwari, give your name.
Lordship, last Friday we have received the additional affidavit, so Lordship will go through it. Kindly fix the matter on any another day.
You have filed, they have filed a reply.
I have filed additional affidavit, my lord. I have filed on 2 in 5 cases. First 32 and 33. We have filed on 6th of this month, and 34, 5, 6 we have filed
How many
Friday.
matters are there?
5 matters. ma'am.
5 matters. That's-
Oh, all these things.
6 and 7 I have
So
filed.
what do you want now?
My lord, it is also
But
not on.
can they fix the matter on any another day? Because we have received the additional affidavit last Friday, so we'll go properly, go through it properly.
Okay, Miss, you are not ready.
Not yet, not yet.
Miss so-and-so, the learned standing council of the PNRD expresses that she is not ready with, to argue
That's-
the matters
Let's see, we,
accordingly. List this matter when you will be ready.
after 2 weeks, after 2 weeks,
Is submits that she will be ready after 2 weeks. Is this matter again on 24th, you will be ready?
that's
On 24th of August. Now it appears on behalf of the petitioner as well as the respondent. You are a petitioner.
Lordship,
What is this?
Lordship. Earlier required, my lord, social welfare.
Ardeka's name has been shown in the cause list.
Shown in the cause list today, my lord.
In spite of the name of the Standing Council of the Social Justice and Empowerment Department being shown in the cause list, the said department is not present, is not represented by the council. Considering the above, this court for the ends of justice adjourns the matter to be listed again on 26th of August 2026. If on the next date, the Social Justice and Empowerment Department is not represented, this court shall proceed with the disposal of the writ petition on merits on the basis of the materials available on record.
He had filed a representation and we have informed him, Lordship, on 23rd July 2026.
Yes.
Informed. Not, we have informed him that it cannot be done, Lordship, because he has submitted lots of documents, Lordship, but which are irrelevant along his representation, Lordship. We have
Now, Mr. Petitioner in person, you had a firm of 3 partners.
Yes.
One partner died. So what happened thereafter?
The another partner withdrew his partnership from the firm. So that's why I'm the only remaining proprietor of the firm. And there are, Your Lordship, they are misleading the court also to their authority also. They are not enabled here and to submit the registration certificate to 2011 when my firm was converted from proprietorship to partnership. And in 2019, that is there, one partner was replaced by another. So they say they cannot be done in as per contract manual. It was done as per contract manual. I will submit in the reply. And secondly, there are 2 objections that no work was secured for 3 years. Okay, my firm was banned. There was a slow progress, so I cannot participate in the tender. That's why. And at that particular at that point of time, I had a workload of around 50 to 60 lakhs, so I didn't participate. And second, the GST. There was up to 20, I filed that GST, but after that, there was a problem in payment and my arbitration petition was there, my claim was there. So I didn't submit this GST form. So when there was any recovery or the claim from the GST, I will submit, I will deposit it. So nothing to bill. And they said they it not enable. Here I want to give this report.
Now, what are you asking for?
And the remaining document that is given is my partner has floated another firm, and the document is under Adil Construction. He has the document. He has submitted the document, so it has nothing to do with my firm. Since he has withdrawn his partnership, so I am not concerned with that document that's enclosed within the Adil Construction in name of Hafizur Rahman.
Now, what is your representation?
I have as per your lordship, as per High Court order, I have submitted the reply they wanted in their previous letter. That there is arbitration or there is claim demand against me. That's why I replied in my affidavit. In reply. So now they are coming up with different excuses only.
Where is the letter that you have submitted that MEA, MIC letter के हिसाब से ये दिए ना?
Now you want this firm to be registered as a partnership firm.
Proprietorship. Now I wanted to change the constitution from partnership to proprietorship.
Using the same name.
Using the same name.
Now, do you have, upon dissolving, do you get the name, the goodwill of the firm?
Yes, Your Lordship. That's why I'm submitting it now.
There has to be, that person has to give up.
Yes.
Has he given up?
Yes, he has withdrawn his partnership. I submitted the dissolution deed, and he has opened a new firm.
I'm not on that. You see, once the partner has died, let's see, I see your partnership deed here. Where is the partnership deed?
Dissolution deed was there. Dissolution deed was there, Lordship. Not the partnership. Dissolution deed was there, Lordship.
Ah.
In Lordship, that deed, paragraph number 5. Here it is stated that after the dissolution, the partner shall not carry out any professional activities in the name of the firm.
Which paragraph?
In paragraph 5.
So, how is it possible? You come at 2. To dismiss your
I want to supply and reply as Your Lord.
No, This needs to be finished up unless you say. Sealing of the petitioner's office premises situated at Station Road so and so, and thereafter keeping the petitioner's office premises under seal for the past 4 months is illegal, unauthorized, and contrary to the mandate of Section 67(4) of the Act of 2017. Accordingly, the respondents herein, more particularly the respondent number 4, are directed to deseal the premises and hand over possession of the office premises to the petitioner situated at so and so forthwith and not later than 12/8/2026. At the time of desealing and handing over possession of the office premises to the petitioner, the respondents, more particularly the respondent number 4, are granted the liberty to take custody of the books, documents, things which were seized and marked as Exhibit 1 to Exhibit 105 from the petitioner, if, in the opinion of the respondents, the same are still necessary for their examination and for any inquiry or proceedings under the Act of 2017. The respondents in such circumstances shall issue a fresh order of seizure and provide a copy to the petitioner. The fresh order of seizure shall relate back to the order of seizure dated 1/4/2016. The respondent shall consider if the petitioner desires copies of the documents which have been seized, unless it is the opinion of the respondents that taking copies / extracts of the documents may prejudicially affect the investigation. The order of prohibition in Form GST 1 dated so and so is set aside and quashed, as the goods mentioned in the annexure to the order of prohibitions are not goods liable to be confiscated. So, Mr. Bhuya, you immediately take steps for the purpose of releasing it. It is totally inconceivable that you will search and seize the documents and hand over to the petitioner. No, cannot. That is not the law. Seizure has to be, once you seize, it should be in your possession. Mr. Mishra, you have got more than what you asked. Uh,
Your Lordship, I want to make one submission only.
What?
I want to make one submission only. that I may be allowed to change the name of the firm and it is as per their contract manual.
Oh, then you have to apply for a fresh registration.
Fresh enlistment, but I request to whatever the category I had and in which category I can participate in the tender. So that may be included and it,
Mr. Counsel, Mr. Petitioner in person, first of all, what is your prayer in the petition? That the partnership firm should be allowed to be used as proprietorship. In terms of the deed of dissolution, you cannot use the name.
yes.
So therefore, that cannot happen. So therefore, your petition in view of your deed of dissolution cannot be. Any other thing you want to do, go ahead. That's your lookout.
The respondent may be directed, otherwise it will not. That is my only submission. It is a question of my
here.
livelihood, your lordship.
Mr. Sharma, these are things which cannot be given here. If you want, you file. Then if you want, engage a proper advocate for this. Because what you have done in your petition, it has not been done properly.
I understood, whether I didn't,
Mr. S. Sharma,
this
the
paragraph.
petitioner in person. And Mr. S.S. Roy, the learned CGC. The present petition has been filed by the petitioner seeking a direction upon the respondents to carry out the change of the constitution of the petitioner of the firm, namely MS Meghalaya Engineers and Agencies from partnership firm to proprietorship firm. The materials on record show that the said partnership firm, namely MS Meghalaya Engineers and Agency, initially was constituted with 3 partners, namely the petitioner,
Sanjay Sharma.
one wife and one Hafizur Rahman and
It's Murthy Sharma, my wife, that
Murthy Sharma. You were not a partner.
yes, I was the partner, Sanjay Sharma.
No, Murthy Sharma was a partner.
Yes,
Mrs.
so,
Murthy Sharma.
that's
Mrs. Murthy Sharma, Sanjay Sharma and Adil
Hafizur Rahman.
Hafizur Rahman.
Hafizur Rahman. Who expired?
Mrs.
My
Murthy
mistake.
Sharma.
The petitioner's wife, namely Murthy Sharma,
Murthy Sharma.
expired. Thereupon, the firm was dissolved by the deed of dissolution dated
24th day of October 22.
24/10/2022. It is the case of the petitioner that pursuant to the said firm having been dissolved, the enlistment of the said firm, partnership firm, now is required to be continued through the proprietorship firm of the petitioner in the same name. The petitioner thereupon requested the respondent authorities to do so, which was rejected by the respondent authorities, for which the petitioner approached this court by filing the present petition. This court duly takes note of the deed of dissolution dated 24/10/2022, wherein, amongst others, it is specifically mentioned at clause number 5 that after the dissolution, the partner shall not carry out any professional activities in the name of the firm, namely Meghalaya Engineers
And agencies.
नाम तो क्वेश्चन ना Meghalaya Engineers and Agencies. In view of the said stipulation in the deed of dissolution, the petitioner cannot claim to use the name of the firm, namely MS Meghalaya Engineers and Agencies, the consequential effect is therefore the enlistment which was made, enlistment of the firm, partnership firm, namely MS Meghalaya Engineers and Agencies, also ceases to have effect. Accordingly, in that view of the matter, the present writ petition, the relief so sought for in the present writ petition cannot be allowed, for which the writ petition stands dismissed. Before parting with the record, this court, however, observes that the dismissal of the instant writ petition shall not preclude the petitioner to submit a separate application seeking enlistment as a proprietorship firm without using the name MS Meghalaya Engineers and Agencies.
The category may be included, Your Lordship.
But
There is some category under which I can participate. So that will be the benefit.
if I don't mention, it is much better. You
Okay.
can do whatever you.
I have taken up the matter with the authorities, and Lordship, the guidelines of the PMGSY, which we have already annexed in the first affidavit, it is coming in the way, in fact, as per the norms of the PMGSY, which we have annexed, if Lordship kindly takes up our affidavit in opposition, filed in the matter, kindly consider para 6 and para 7, The first affidavit, filed by the chief engineer in the matter. It is by page number, it starts at page number 40, 47. 44, Para 6, kindly see, para 6 and 7, these are important,
When was the defect liability period over?
It was over by your lordship, 23/11/2024, your lordship.
11/2024.
Lordship.
And this letter is of 30th of April.
Kindly, if Lordship takes up that later, in fact, 30, page 55.
That is what I am reading.
This refers to 20th of July 2023, para 2, That is also available at page 56, In fact, the ministry's guideline is there in the month of July 2023.
This has no relevance. When was the inspection made?
Well, inspections were made in in fact, subsequently we have
No, not subsequently. This letter has no relevance. Does it say about this thing? This is a guideline.
the
I'm not on that. My question is here that the defect liability period was over on 23/11/2024.
But
Thereupon, any letter has been issued pursuant to that or any inspection being carried out, we are not bothered to that effect.
in fact, in the second affidavit, we have brought that in 2023 letters were issued at page 73. It's a part in the affidavit. These are the letters. During that period, the defects were there. He was intimated that the defects are there in the road. So you do the maintenance work.
Lordship, but however, certificates were issued.
Those certificates were ultimately the defect liability clearance has to be in the portal. The port as per 30th of April 2025, it has to be issued through the portal only. In the portal, it shows that those defects are not, the repairing works are not done by the petitioner. Although, yeah, I do admit, I do admit that the executive engineer has issued some letters, but those letters are not as per the guidelines. That is the difficulty. That is the difficulty,
So if those are without not as per the guideline, this very executive engineer had provided the completion certificate also.
But in fact, the guideline provides that it has to be the defect liability completion certificate shall be generated through e-mark for release of performance security deposit. It is the as per the guidelines of the particular work and the ministry guideline. But the certificates were issued, and when it is there, if necessary, under what circumstances that has been issued by the concerned officer, Lordship directs, we are ready to have an inquiry. I'm not on that. But the difficulty.
No, you have to be on that. You have to take him, suspend that officer. No,
Lordship.
first of all, suspend, take up a disciplinary officer, throw him out of the job, then only we can consider anything else. You cannot escape with that. On one hand, you hold to only put him into the petitioner into a year. The order is very clear. In fact, my earlier order was very clear to that effect. So therefore, you cannot keep on raising this issue out here. If you have not taken any action against this official, you can't help it.
But the works, this is not the single work. These works are there. A lot of work.
Whatever may be, I'm not on that. This
in
is a
fact-
completion certificate being given. Defect liability period is over. Executive engineer has given it.
In fact, the portal shows that since the maintenance work were not done by him, therefore, when the
Defect
Routine-
liability
routine
certificate has
routine inspection and performance evaluation is
5
done.
years from the date of completion is over
Lordship.
on completed on 23/11/2024. This is being given by the executive engineer PWD.
This is what I am apprising before your Lordship. This is not as per the guideline of the ministry.
Understood. Then why did he issue? And what action have you taken
And
against him?
in fact, as per that certificate, the defect liability period cannot be treated to be completed because the defect liability period certificate generated through e-mark only can be easily acceptable in this particular work. The routine inspection.
Where is it mentioned that defect liability has to be given by the e-mark certificate?
Paragraph 6 and paragraph
No.
7.
Documents. Which document says that it cannot be given by this way?
Page 55. Page 55, kindly see para 3 to help states a utility has been developed in the eMark DLP module with a provision for extension of DLP for the non-performance period. The system will calculate the non-performance period of P marks less than 80%, and for that period, the DLP shall be extended and certificate of extension of DLP period otherwise shall be generated after satisfactory performance in the extended period. The DLP completion certificate shall be generated through eMark for release of performance security deposit.
This is, they have written, but where is that guideline for that?
They have been referred to a letter of 20th of July 23 that Lordship will find at page 56.
So you mean to say page 57,
Malad.
the release of the performance security shall be allowed only when the eMark generated defect liability period completion survey mentions. So without this,
Malad.
there cannot be a release.
There cannot be a release. And in respect of this work, Malad, Lordship kindly takes up page 53. The portal shows, Malad,
Yes.
when the data were uploaded in the portal shows unsatisfactory performance due to less than 80% marks in PE performance evaluation, and the consecutive PE of the same segment getting marks less than 80%. More than one segment is getting less than 80% mark of the roads in the package are allowed. Therefore, total unsatisfactory period is 20 in months is 28. And Malad, finally, page 54, Malad. The answer.
Who has signed this?
This is system generated, Malad. On 15/5/25, Malad. Kindly see at page 54 bottom, Malad, digitally signed by Himanshu Das.
Tell me, if this is 15/5,
Malad.
then why this executive engineer have issued this on 22/4? 24/4 at page 37.
Malad, these are issued manually, Malad, without following the guideline.
We have a PID inquiry on this.
Lordship.
Because this particular person, either this person is responsible, he knew or is this officer not aware of it?
Malad, he should.
What action have you taken against him? Because this was issued on 22/4.
Yes, sir.
And this document is of 15/5.
In fact, the guideline is in force since July 2023. As Lordship has seen.
For 2023, the guideline is required.
True, Malad, true.
Now, the defect liability period, this guideline was based upon what? Did it mention anywhere? Was this guideline in existence at the time when the work was allotted to the petitioner?
In fact, these are Malad, PMGSY works, and
No, there has to be at the time, because he has to know. that at the time when the completion will be done, the period of defect liability will be released only upon the defect liability certificate is issued in the e-mark. Is it the aspect pertaining to in the year 2023, was it a part of the tender document?
Well, as per I have, well,
Produce the tender documents for this e-procurement notice dated 24/2018.
Lordship, I have it. I have the document, your lordship.
Show me whether it is mentioned.
Lordship, it's the, no, it's 30, clause 32. Because these were not there, your lordship. These guidelines were not there, and lordship, clause 32,
Engineer shall give notice to the of any defects before the end of the defect event. Every time notice of so and so is given, the contractor shall correct the notified so and so within a month. Shall do the routine maintenance of the work, including pavements, so and so, so and so, so and so, so and so. Does it refer anywhere to
No, sir.
any of these guidelines?
No,
Or
these
these guidelines is based on when? This 2023
Mala.
was based on when? Was it a part of the tender document?
In the tender document, I have not seen, Malad,
No,
but
if it is not, it have a mention or referred to the PMG wherein it is required that it will be in there in the e-mark.
Correct.
You cannot incorporate a new condition subsequently.
But in fact, the entire work, the entire scheme, it is under a scheme of the ministry, Malad.
Well, understood, but
And
now the
from-
question is subsequent to the work being completed. Work was completed in 1 year
In Malad, in the month
and the
of, yes,
defect liability period ended on 23/11/2024, that is after 5 years.
lordship,
So the tender was issued sometime in 2018.
18.
Then 1 year the work was completed and 5 years thereafter. So therefore, on 23/11/2024, the period ended.
Lordship.
Now you
During-
have extended the period, admittedly, on 15/5/2025.
But lordship,
Now, this is apparent from your document
But-
at page annexure A, page 53.
lordship.
Now, wouldn't that be contrary to clause 32?
But during
No, Mr. Counsel. Wouldn't that be here to clause 32(1)?
But in fact, Malad, during the defect.
You show me the show cause notice as well as the suspension of that executive engineer, then I will think something else. Otherwise, no.
But in fact,
No. Your officers cannot go scot-free, Mr. Counsel.
lordship,
The officers cannot be scot-free.
that is a vital aspect, Malad.
No, that needs to be one. Secondly, we have to look into it whether you can now raise this issue of 15/5, extend it prior to, because here categorically at page 53, you say what is the date of completion. Stipulated date of completion is 23/1/2024, page 53. On top.
Lordship,
So you admit to that. What is the stipulated date of completion?
lordship.
Now, can you extend it after that?
But in fact, before completion of the defect liability period, several notices were given. to-
Understood, but the fact remains, after the defect liability period or prior to the ending of the defect liability period, did you extend it? The question is there. You see this particular document, you can go ahead, Yoksu. Show it to him. You cannot extend it beyond that 32(1).
It will-
Read 32(1).
Lordship. The engineer, 32(1), the engineer shall give notice to the contractor of any defects before the end of the defect liability period, which begins from the completion date and ends after 5 years, The defect liability period shall be extended as long as the defect remains to be corrected.
So therefore, this has to be given, extension has to be given prior to the completion.
Lordship,
So when did you complete, extend it prior to the completion?
well, in fact, in this,
What? You see, those letters of 2023 shows that they have not carried out maintenance and all these things. This letter of 15/5 should have been dated prior to 23/11/2024.
well, why this has happened, my lord? When these datas were uploaded in the website to have the completion, defect liability completion certificate as per my lord, 30th of April 2024, 2025 SOP, which I have shown at page 55.
No, first of all, no, your SOP will come later on. Your SOP, if it is not a part of the tender document, has no relevance. We are not concerned with others unless your PMGCY, whatever may be, stipulated that there is a requirement of having the defect liability thing, the certificate to the defect only to be given there. That is another aspect of the matter. But the first and foremost remains the question is, as on 23/11/2024, the period concluded. Did you extend prior to that? That's the only answer. If you have not, matter ends. We are not concerned with others. Forget about that certificate of the engineer. Did you extend prior to 23/11? If you have not, matter is over.
My lord, in
Now
the-
we'll let us argue on the question of interest and who is going to pay.
but lordship may kindly consider, my lord,
No.
the difficulty. faced by the
Others are not,
department.
we are not concerned because you see, you have to immediately amend your contract. You should have amended the contract that you look here now while the contract is going on. You see, now it will have to be done on this basis. You didn't amend your contract. The contract remains as it is. You see, being a contract, you cannot change your stand at a later stage
But during the
after the completion of the work.
during subsistence of the defect liability period, these developments are well known to the petitioner, my lord.
Understood, but why didn't you extend it?
In fact, my lord,
Where is your extension letter prior to 23/11/2024?
the notices which were issued to him,
Did you extend it? My question is, did you extend it?
it automatically gets extended. my
No,
lord, because he
it
has not
cannot be
completed them.
automated. Show me that provision in the contract which says that it automatically gets extended.
Because he has not completed the work.
No, he has completed the work. It is the defect liability period. The completion is done because unless it is not completed, the defect liability period would not start.
My lord, contract has two parts. One is, my lord, the work, he will complete the work. Second is, my lord, the repairing part. Repairing for 5 years, repairing contract. Two,
It is not repairing, it is maintenance.
my lord, no, my lord, kindly see.
Yes, it is maintenance.
Kindly see, my lord, page 31,
Hmm.
maintenance. So these two parts and that second part for maintaining the work in 2020.
Why didn't you extend it? You didn't extend it.
Look.
So therefore, by automatically, it ceases.
The portal,
And this is an admission on your part on the basis of your public works department, whoever it has done it.
the portal shows, my lord, the guideline of the ministry shows that
No.
when the maintenance work is not done by him, the defect liability period automatically gets extended.
What is the commercial interest?
Lordship, my lord,
Commercial interest.
kindly consider the difficulties faced by us.
No, we are not concerned with that. You have to pay, you have to pay.
No.
We are not concerned.
Lordship,
If you are not, that I think, whatever may be, however you want, you do, whatever you do, that is your lookout. But the fact remains that and that too, when you are doing work you are doing as an agent of the central government.
that is why, my lord, we
So
are. what
therefore,
difficulty?
when you are agent doing, and understood, the PWD may throw out the money which is given by the state, no problem. But when you are doing, you have to be more careful. And if your officers are not careful, then you have to take action. And your action is not being taken upon the official. You want to penalize the petitioner. This court finds it very inequitable.
Well, ultimately, the system generated certificate is required for release of the amount at this.
But system generated certificate did not come into being in the contract. What is the contract you have entered into? Can you change the contract? Or unilaterally? Or is it because of the central government or the state government doing or whatever they are doing, they can do anything? It's a contract after all. So the contract is the agreement between both the parties. The agreement between both the parties contained clause 32.1, which stipulated that it is the requirement of law that you have to grant you have to direct extension prior to the period being over, which you have not. So therefore, if you have not extended it, you extend it on 15/5, that extension cannot happen after 7 months. Otherwise, if we allow this type of repetition, dismiss the repetition or allow you to do whatever you feel like, there will be no rule of law. So, or if you want to say that for a PWD department, they can do anything they feel like, let them do it. But this court would not allow this.
Not our interest is, the public interest is to be protected. That is what we have
How the
said.
question of public interest? So
definitely,
therefore, the question is, therefore, your question is, you should have taken action against the executive engineer and said, whoever it is, whoever was responsible for granting an extension, not doing it prior to 2311, then only this court can think, yes, the department was due by its officers for which this court should think about public interest. But no, your department wants to do whatever you feel like. You don't blame your officers in doing all these things, but blame the petitioner because he has not done so. That cannot be the ground.
Malad, I am not Malad, arguing for the petition, the executive engineer who has wrongly issued the certificates. Malad. In fact,
Forget about his certificate.
In fact, the portal
Forget about
shows-
his certificate. This document at page 53 makes it clear that it is your self-admission to the effect that period ends on 2311. The fact is that particular officer concerned did not grant a direct the extension of the period of the maintenance period because of the for whatever reason he did not do it. Why should this court, if you don't take any action against that officer, why should this court?
Specifically, although Malad specifically he has not said, but several notices were given to do the repair, the maintenance work.
Understood,
that-
but why
that is
didn't
not
you extend
specifically
it?
spelled.
Where is your document notice to that effect that we'll extend it? Have you mentioned anywhere
Well,
that you have to do it? No, those documents are not there.
if the works are not done
You cannot.
within that
Sorry.
period, Malad, within that period, ultimately the guideline says, Malad, that it gets automatically extended. That is what Malad, that is what the guideline provides.
Now we argue on the interest question.
Lordship, kindly consider, Malad, it is
9%,
it
9
is-
or 12,
but this is not a
9%.
this is not a
Commercial
Malad.
interest.
Kindly see, Malad.
And that should
Ultimately-
be taken from the chief engineer PWD, whoever it is, whoever is responsible. From his salary we deduct.
Malad may kindly consider.
I
Malad.
think the division bench will help you out. I'm not going to do allow. This type of thing, my order was very specific.
Yes,
Under the-
Lordship,
in
in
view of
fact-
the stand taken pertaining to clause 32, this court permitted they to file an affidavit to justify their stand. In the affidavit so filed recently on so-and-so, this court duly takes note of that within a span of 3 months, from so-and-so to so-and-so, various notices have been issued by the executive engineer to the period to carry out certain maintenance work. These notices were dated so-and-so. However, subsequent thereto, the said office of the so-and-so had given the certificate on so-and-so, categorically stating that the defect liability period was over on so-and-so. Under such circumstances, the question of extension of the defect liability period in view of Annexure 1 to the writ petition does not arise. Today, so-and-so has produced certain documents which were issued to the petitioner for complaint. All these documents are of the year 2026, and it appears that these documents have been issued as a fallout of the present litigation. Under this court does not find any justification in withholding of the said amount due to the petitioner, and accordingly it is the opinion of the said amounts is payable and ought to be paid. This court is also of the opinion that on account of the action on the part of the respondent, the petitioner have been deprived of the dues unreasonably. Under such circumstances, a question arises for adjudication of imposing of in commercial interest upon the respondent. It is the opinion of this court that imposing any interest upon the respondent so that the amount of interest can be subsequently recovered from the salary of the erring officials of the respondent for the delay in releasing the performance security as so and so. This court should grant an opportunity to explain clear. List the matter on which date this court shall take up the petition for final disposal. This court has already held it. I'm not going to change my opinion on that. Now, interest.
But
Who is
I-
the official from whom erring official?
But I respectfully submit,
PWD.
I respectfully submit, my lord, lordship may not direct interest, my lord. But,
No.
in fact, the stand we have taken in the affidavit.
No,
at
your stand, that is the
Para-
biggest problem. You had made, I would have definitely considered it. I would have been more reasonable on that aspect or looked into very well.
Not
But
kind-
I cannot allow the PWD department and its official to do whatever they feel like. Open up whatever they, yes, this court would have very well considered the defect liability period on all this thing. But unless you say that, look here, these officials were responsible who had not granted the extension, for which we have taken steps for suspending them and further taking action against them. Disciplinary actions have been taken for whatever may be, for unless you don't do it, we can't help.
But the, but actions will be taken, but against the
You
erring.
have not. The writ petition has been pending for quite a long time.
But-
2025.
But this text has come now, my lord. Now, in fact, paragraph 6, 7, 8, and 10 of the affidavit, we have made it very clear.
Those have been
that
duly
is the-
considered,
That
Mr.
is the,
Mr. Counsel, Mr. Counsel, all these things have been duly considered.
lordship may.
And this court had passed an order. Only way by which this court can change its opinion was if you had suspended these officers and then initiated disciplinary action. If you have not, this court has not, which you have not. So therefore, it cannot be a one-sided affair.
But
Now, interest will be paid by the chief engineer. He is responsible. The public works border roads.
my lord,
It should be taken from his salary as well as the commissioner and secretary, half up. Commissioner and secretary to the government of Assam Public Works Department.
but this is
from
not
their
a,
salaries.
this is not a deliberate act, my lord.
It is a deliberate act
But kindly-
on the part of
kindly-
it, and more
kindly appre-
particularly from
kindly appreciate-
27/7, from that date on which I passed the order.
No,
That
no,
is
in
a
fact,
deliberate act. So we therefore, I have given the opportunity to all the respondents to argue on the point of interest. So therefore, why interest should not be given?
my lord, I respectfully submit, my lord, that interest may not be considered because my lord, they are bound by the guidelines.
I can't help
And
it.
as on today,
No,
as
all
on
these things
today-
are understood that they are bound by the guidelines, but the fact remains that this aspect have been duly considered and your affidavit has been duly considered in that order. And this court specifically mentioned, forget about other things. Why didn't you extend within the period from 2023-11? Forget about his certificate of that 25-4. We are not concerned. Why didn't you extend prior to 23-11? That's the issue.
but in fact, our stand is that it gets automatically extended and as per.
Where is it mentioned? You cannot say that it automatically extended.
Since the.
No,
portal-
the contract has to say. Does the contract document say that it gets automatically extended?
The PMGSY guidelines formulated by the
Show me that.
ministry,
it says
it is,
at all.
it is applicable, my lord. If-
No. You see, PMGSY, the guidelines, so if it is issued subsequent to the contract, has no relevance. It has to be prior to the contract.
But it will be very difficult situation for us in that case because this work it was in 2018. And
Yes.
ultimately the work,
So you understand or you appreciate that you have a difficulty in producing the guidelines prior to 2018, but you have no difficulty in having him carry out the work of 2018, maintaining from 2018 to 2027. Is it reasonable, man?
kindly appreciate, my lord.
No.
Kindly appreciate when during the defect liability period the contractor is not maintaining the road, not repairing the road.
Why didn't
And
you
also-
extend? My question is, why didn't you extend? Unless you show me that the PMGSY guidelines related to or required that it has to be as per the E-mark prior to 2018. You show me that. Show me that. Once you show me that, you have a good case. Show me that. Or show me a particular document of which shows prior or at the time of when the contract was entered into, that it required that without there being a completion certificate being granted by the E-mark, it gets automatically extended. Show me that.
But it came in, I have seen in July 2023, Malad. Because when the problem came, then only the clarification came from the ministry. Because during the maintenance period, Malad, they did not maintain the work, and having those difficulties, the ministry has clarified in the month of July 2023. I can't show, Malad, in the year 2018.
So unless that is not there, can't help.
But the department has to follow whatever the ministry has said,
So,
Malad, in
so
July
ministry has given subsequently.
July 2023 guideline is there, and in
Mr.
One.
Nath, you have to understand,
One.
July 2023 guidelines would not hold any water, taking into account that these guidelines has to be, or is it mentioned out there in that contract document that, or any modification of the PMGCY guidelines? Is it mentioned anywhere? You don't prepare in that manner, you prepare in that manner. If it is mentioned, then I can take note of that. But if you don't mention it, don't show me something, I can't help the department. First, you don't take any action against your department. You don't show me any document. I cannot take on the basis of your verbal submission or your incapability now to show any document to that effect. You will have it in your guideline. Or is it that you, what you call, throw away or burn away all these documents? No. You must be having it. Find it out whether the guidelines or the contract documents stipulated that this is under the PMGs. So it will apply as per the guidelines as well as any modification thereafter. Then obviously 2013 will come in. But you don't show me that. If you don't show me that, give me a handle to help you out. But I can't help you out unless when the petitioner has been able to make out a very strong case against you.
there has to be, Malad, there is, Malad, there has to be.
You find it out. See the contract agreement. And in that contract agreement, there may have been a mention to that effect that all any other guidelines which are or any modification thereof. There might be. If it is there, you get it. But otherwise, the petitioner has an ironclad case. It's not that I have anything against the PWD. I will help you out, but provided show me something.
True, true.
If you don't show me anything to that effect, I cannot help you out.
Not
So, but the question is, if I allow the petition, interest will come. Interest will come. Interest has to be paid by these officials because I can't blame the state because of the inefficient officers. State's money is, after all, people's money, your money, my money, everybody's money. So therefore, it has to be from the salary of those officials. I make it very clear. So unless you show me this particular document, one line here or there can help you out. Otherwise, you don't have a case.
correct.
Yes.
No, I'll try to show, Malad. Kindly keep it tomorrow at 2, Malad.
No, not tomorrow. I've given you so much time when tomorrow not possible. Tomorrow lots of matters. Itu nahi. নাযায় নেকি এইটো বেয়া হৈছে নি বছ নহয় কিয় এখন ওলাই আপোনাৰ তাত আছে নে ওলাওকচোন এখন ওলাই দেখাওকচোন ইয়াত But I make it very clear. This court is otherwise going to interest as well as to the officials. If the commissioner and secretary PWD is responsible, is it the additional secretary, chief secretary?
No, in PWD, he's this Commissioner and Special Secretary.
Commissioner and Secretary, he is the head of the department, so he should also be partly blamed. So from his salary it will go, and from the chief engineer, his salary. Others, we are not concerned. You can very well take it out from the executive engineer. You know how to take it out from his. Interest won't be much. 9%, how much? Along with some cost, we have to put it. Otherwise, it would be very demeaning for this court to pass that order. Interest will be how much?
9.
1-2 lakhs plus another 1 lakh as cost. I said. Hello. The matter having been heard at length, lists this matter for further hearing on 25th of August 2000, no, 25th I have a big matter, 27th of August 2006, at the top of the list. This is the final chance, no more.
Lordship.
1 lakh cost, other interest. What is this?
Your Lordship, my work, I completed the work way back on 31/3/2023. Completion certificate was issued. Defect liability period expired. After 2 years, they sought to encash the security deposit on an alleged ground of unsatisfactory work without issuance of any demand, without anything. My submission is that once the defect liability period, completion certificate, final bill been released, the contract ceases, and therefore railway could not have made any claim against me.
Why was the BG lying there in
Your
2025?
Lordship, what happens is that this is against the running bill. From each running bill, they deduct money towards security, 10% towards security deposit. After the work is completed, if I want the cash back, then I give a bank guarantee in lieu of that money taken up towards the thing. It is not towards performance, because performing bank's guarantee was already.
Why the bank guarantee is till when?
It was valid, the claim period was till 25 and till 31/7/2026, the claim period was valid. Bank guarantee was valid till 31/5/20.
Into July.
Huh?
31 July 2020.
31 July 25, bank guarantee. Claim period was there up to 31/7/2026.
Claim period is?
Means there is a validity of the bank guarantee. But even after the expiry of the validity period, they have a further claim period of 1 year
On that bank guarantee.
on that bank guarantee.
That
No,
may-
but the question is, if there is an unsatisfactory performance, what do you say about this completion certificate?
My lord, the completion, after the issuance of the completion certificate, my lord, certain serious deficiencies were found. The pillars, my lord, were not executed, the work of the pillars,
But
my
it
lord.
had a defect liability period.
Even after that, my lord, they will have the liability. If there is some error in the
Is
construction,
it a part of the contract? Is
yes,
it permissible?
yes, my lord,
How?
it is permissible, my lord.
Show me the term.
And my lord, this bank guarantee is in respect of a different contract, from a different contract, my lord, we have, my lord, invoked, encashed.
More in the affidavit, we have mentioned.
It's okay. My question is very, how can you do it unilaterally?
No, look, there has been an inspection. Inspection was carried out. The defects were found.
Whether any adjudication process was there?
No, my lord, the authorities can, my lord, take the amount on lien. My lord, the cost of repairing those defective work, my lord, that has been assessed. And that has to be done by the same contractor. Till that work is
But
completed.
therefore, did you inform him that, look here, your work is not satisfactory?
Yes, my lord, he has been informed, my lord.
No.
Where?
In paragraph 18, page 79 of their affidavit, they don't say.
No, all these things. Affidavit, you cannot give evidence by way of an affidavit out here. What you have to do has to be based on documents. Do you have the power to do that after the defect liability period is over? If you don't have, matter ends there.
No, under the contract, even after the
So
completion.
therefore, if there is a contract, so
Madam.
there will be a term in the contract which permits you to do that.
My lord.
Where is that?
And it is there, my lord. My lord will take page 35 of the writ petition.
Yes.
Clause 52,
Okay.
35. My lord.
Ah.
Clause 52, my lord, which deals with withholding and lien in respect of sums.
Where any claim or claims for any payment of any sum arises out of under the contract against the contractor, shall be entitled to be told and have a lien to retain such sums or this has nothing to do on that. My question is, after the defect liability period is over, then can you, on the basis that there are certain defects in whatever he has done, impose an amount upon him without resorting to some proceedings? My simple question is this: if you don't have, matter ends there. If you have, very well, you may behave. Otherwise, where is the question of filing you have an arbitration clause.
Is there.
Why don't you go to, means why there is an arbitration? Always people refer to the arbitration if there is a dispute to that effect, that you ask him to pay that amount. This is the year, and otherwise he may contest it. Now, question is, you have not done anything to that effect. One fine morning, you say that, okay, we take this amount. How is it possible? Find it out, properly prepare your matter. Very poorly prepared.
My lord, today itself they have given the reply, my lord. I have not.
Oh, forget about it. I am not on their reply.
Gone through it.
I don't see the reply, but you know your affidavit.
My lord.
You know your petition.
Yes.
You have seen the writ petition, so I am concerned with the writ petition.
I'll take instructions on that.
Taking into account that the affidavit has been filed by the petitioner today, Mr. H. Gupta, the learned CGC, submits that he may be given some time to the same and prepare the matter. This matter again on 26th of August 2026.
Interim to continue, Your Lordship. Interim.
Interim for what?
The
Encashment has been restrained. Encashment has been
restrained.
We have invoked the VG, but my lord, they will also extend the VG in case the VG is not valid. They should also extend it, my lord. Otherwise,
The interim order, so past earlier stands extended, subject to the petitioner extending the period of the bank guarantee.
Your
Otherwise,
Lordship,
no extension.
no, Your Lordship, may just have one aspect.
Otherwise,
said
don't
that
ask that. Don't ask me all these things.
Your Lordship, the bank guarantee is not with me only. They send it to the bank.
You can very well extend. Mr.
invoked it
Senapati, this is nothing new to me. You can very well extend it. You want an adjudication. If there is an interim order, because after that, what will happen?
No,
If the writ petition remains pending,
that is
then what will happen?
No, your lordship, what they say is that they have encashed the bank guarantee, converted into a demand draft, and the money is lying with them.
No, my lord, encashment has been restrained. We have invoked it, my lord. There are.
We have
lordship,
invoked
it's-
it,
see,
and
they have
it
to-
has been
We
restrained.
invoked it.
How, interim order to the, we vacate that
We
interim.
invoked it. We have not
No,
encashed.
No, we vacate the interim order then. This type of interim order cannot remain. You want an extension, it has to be extension subject to.
The
Because,
DD is deposited by account department to the bank on 31 so and so balance amount. So
interim order, my goodness, it cannot be.
it is already
The communication for encashing shall remain, sir. However, in the event the HDFC had already issued the demand, that the said demand shall not be encashed. So that,
demand draft is there with them.
has the
That's
demand
what-
draft been issued?
Not.
Yes, their affidavit may be seen. It's
It is
written
not
in their
encashed,
affidavit,
Not encashed, my lord.
page 69.
Demand draft, Mr. Senapati, is
We'll have
for
it
a
well.
particular time.
Your
Is the
lordship-
demand draft, Mr. Counsel, can a demand draft remain for?
Your lordship, the line is the DD is deposited by account department on the bank on 31/2025,
Where?
page 71.
Whatever may be.
Then
But it has not been encashed.
how deposit, if
The
it's not that,
interim order stands extended only subject to you providing an the extending the bank guarantee which was given
oh,
till the dependency of the petition. Okay. The interim order, this court have also heard the learned counsels appearing on behalf of the parties on the question of extension of the interim order. It is the opinion of this court that if the interim order is to be extended, there has to be, it is the opinion of this court that there is a requirement of a modification of the interim order which was passed by this court on 31/2025. First, it is observed that the interim order and what is more particularly taking into account that the bank guarantee, more particularly taking into account that the bank guarantee, the claim to the bank guarantee is valid up to 31/7/2026. This court observes that the interim order which was passed on, this court therefore observes that the money that you have already deposited the bank demand draft, na?
Deposited, it was returned to us because of the court order. The demand draft has been written.
we'll give the fresh demand
It was returned.
This court also takes note of that the demand draft which was issued to the respondents by the HDFC Bank upon being deposited was returned on account of the order passed by this court on 31/2025. It is the opinion of this court that any protection can be granted to the petitioner. It is the opinion of this court that while granting the petitioner and certain interim protection, it is also required that the corresponding rights of the respondents is also protected. Accordingly, this court observes that the interim order passed on 31/2025 stands mortified, thereby observing that the respondent, HDFC Bank is the party?
Yes.
The party. The respondent.
Respondent number 7.
The respondent number 7 shall act upon the demand so made by the respondents by the communication dated 29/1/2025. Thereby observing that the respondent number 7 shall be bound by the observing that the communication dated 29/1/2025 issued by the respondent number 6 to the respondent number 7 shall be deemed to be a communication invoking the bank guarantee within the period of the bank guarantee. It is further observed that the respondent number 7 is further observed that the respondent number 7 shall be bound by the invocation made by the communication dated 29/1/2025 and shall encash the bank guarantee bearing BG bond bearing number so and so 264 GT 021829500001 dated 22/10/2018. If in the meantime, within 10 days from today, the petitioner do not extend the BG bond so and so till the pendency of the instant writ petition. You go there and extend it. Pendency of the present writ petition being discussed.
They are just the nodal agency, man. Work orders, Lordship will find.
Page 11 is the work order.
Verify and pay within 6 months.
No, well, what they're saying that you're paid, you've been paid, they've been
Yes.
paid.
We have
Got the
received the
money?
payment, yes, Lordship.
The petitioner, counsel for the petitioner submits that the petition has become infructuous in view of the
All the
fact that
matters.
the petitioner have already received them for which the writ petition had been filed. Mr. D. Gogoi, the learned counsel, appeals on behalf of the animal husbandry.
No, this is PHE, man. We are the nodal agency. It was routed through
Appeals
us.
for the PHE. Writ petition stands closed.
In our item number 41 also, we have received the payment, Lordship.
All right.
May it please your lordship. My lord, in this case, my lord, the BTC has filed their counter affidavit on last week, my lord. So I require, my lord, 10 days time to file our rejoinder, my lord.
Your contract period otherwise ends when?
My lord, within 6 months, that was issued, my lord,
Where is your contract? Letter of acceptance?
page 28, my lord, and except
Page?
28, my lord.
Period of completion 6 months.
6 months.
Now you are in a position to carry out the work.
My lord, because more than 30% work we have already completed, my lord.
30% understood, but the fact remains. The contract was for 6 months.
My lord,
It ended on sometime in January 2026.
my lord, but site was handed over in the month of October, my lord.
But the period is from 6 months from when?
From handing over position, my lord.
Understood. So
That- that is
you will
already
be
over.
able to do the work.
My lord,
My
as per-
question is, where would you be able to do the work now? Because from that date, it has been almost 1 year now.
my lord. I have to obtain instruction, my lord, in this regard, my lord.
Because here, normally when there is a cancellation, you don't get a stay, but there is a stay
There is no statement.
from initiating a bidding process. Now the works have half 30% work you have done. Now, how far that 30% which remains out there is another aspect.
My lord.
Have they made the measurement in the meantime?
No, my lord.
Have you made the measurement?
Worship. As per my instruction, my lord, no measurement was carried out, my lord.
So what remains is 30 must have now become 20.
My lord.
Yes. So then you now have to do 80. Would it be useful on your part to do 80 after 1 year? Financially,
My lord.
that is another aspect.
My lord.
Anyway, look into it. It has been submitted by the learned counsel appearing on behalf of the petitioner that an affidavit has been filed by the respondent number 3. And the petitioner would like to file a reply thereafter. Would like to file a reply. Considering the above, list this matter again on 9th of September 2026. In the meantime, the petitioner is granted the liberty to file the reply.
Right.
Order passed earlier stands extended to the next date.
All right.
My lord, in this matter, we are praying for 2 weeks' time. My lord,
What?
department is verifying the documents, my lord. So as such, they are sending a letter to,
Which department?
yes, police, my lord.
Verifying.
No, they are verifying it. They will, probably soon they will send us the parawise, my lord.
You verify and pay. Within 6 months. মানে পুলিচৰ দিব কিন্তু সেই পুলিচৰ নহয় এইটোত ভেৰিফাই এণ্ড পে
Not you have filed your affidavits. Affidavit.
The petitioner, my lords, here has assailed a demand notice or a show cause notice issued by the excise department in her capacity as a director of a company against certain ad valorem levies towards destroyed stocks that under a license which is owned and operated by the respondent number 6, my lords. Now, the department has admittedly already initiated Bakijai proceedings against the respondent number 6. And my lords, the respondent number 6 against the original demand, my lord, had also filed a writ petition, my lords.
Where is the 1612
I'm sorry, my lords.
show cause notice?
Show cause notice is at page 45. The original demand, my lords, is also part of the writ petition is at page 40.
Gogoi, what happened to that judgment passed by
Justice
Justice
Chaudhary.
Chaudhary?
It is there, my lords,
Sukhdev
holding the
Chaudhary?
field, my lords.
Hmm?
It's holding the field still. It's there, my lords. It's holding the field, my lords. Motibul Hussain,
So
Hazarika.
if that be so, wouldn't they be liable?
The issue seems to be covered by that judgment, my lords, because once the product leaves the bond, whether that incident of sale happens or not, whether you sell it or not, you are liable for payment, my lords.
The
And what is this matter?
this is the order that I just passed, my lords. The notice, the demand, the actual demand, my lords will find at page 40. Is the demand of 11 November 2025 issued to the licensee, my lords. Against, this is a demand for 2 crore 11 lakhs 40,200. The exact very same demand notice has been assailed by the respondent number 6, my lord, who is the license holder. And the petitioner before
No, one is by Purobi Gogoi.
Purvi Bora, my lords, is a director in a company. She has been issued a show cause notice by the excise department on the pretext that she is a director and the respondent number 6 is also a director in the same company, and that company is operating the license under which there are certain ad valorem levied or there are dues, my lords. Now, the show cause notice, if lordship sees at page 45, what they say is, since you are a director in the company and there are dues towards the license that is operated by the company, you're also liable. And the petitioner also operates, my lords, two individual separate licenses under the excise department. And there is there is an apprehension that there would be action initiated against her own license. That's why the petition, my lord. The original demand has now been assailed by the actual license holder, and there is an interim
But
order.
why are you not replying to the superintendent of taxes?
My lords,
Excise.
my lords.
Why you are not replying to the so called reply?
No, there is a reply at page 46, my lord. No, it is perhaps very poorly worded, but there is a reply, my lords.
But Mr. Gogoi, how can you issue a notice to another licensee of another shop
My
or
lords,
demand
the-
certain things?
my lord, the rule stipulates, my lord, specifically rule 296B
What does it
of
say?
the Assam excise rules, my lord. It says individual applicant must submit a Bakijai clearance, my lords. Since in her capacity as a director, they are facing, my lord, these Bakijai proceedings. This will affect this license also.
But for that, you have to go for cancellation of the license notices to be issued.
My lords,
But how do you initiate the proceedings on the basis thereof?
that we have dealt with that contention at page 50, para 8.
Oh, 290?
6B.
Former license.
B. B, man.
C for Punjab.
B, my
B, B, my lord.
License for retail of any shall not be granted to former licensees who are in areas of government or whose conduct has been found to be unsatisfactory and who have. But here the license has been, or they have been already granted.
No, they are not former licensees, man.
Oh,
They are
huh?
license holders, my lord.
Then
Existing license.
how is this?
Maybe, my
relevant?
lords, falling back on B is not proper. Perhaps C covers, my lords. The person, to any person who is in area in respect of any government revenue or dues or is defaulted in respect of any repayment of any government loan.
What?
C. It might not be B, my lords. C maybe.
To any person who is in area in it's okay. My question is, he is already a license holder.
My lords.
Here it says license for retail of any shall not be granted.
My lords.
The license has been granted.
No, that's it's renewal. My lord, they are asking for renewal, my lords.
Where?
Not asking
No,
for
that is not the subject matter out here.
My lords.
Here, why have you issued notice to this? It's because of first. Secondly, a company, whatever may be, is limited by the shares, liabilities as per the company's thing.
My lords. And that we have.
You are referring to as if you are taking the company as if the company's part. How is the directors responsible for the entire dues?
Well, there are 3 directors. We have annexed the memorandum of association, my lords, that they will manage the affairs.
Understood, everything understood. But it's a company.
My lords.
It's a limited company.
Limited, my lords.
So if it's a limited company, whatever maybe it is, the liability is limited by the shares.
My lords. In
So
fact, my lord,
therefore, to
we
that
have also.
extent, you have to go for liquidation of the company.
In fact, my lord, para 6 of affidavit, my lords, the
No, you
petitioner.
cannot claim from the directors directly. You have to go through some insolvency proceedings or whatever proceedings, whatever may be as regards the particular company. You cannot do so on the to a private
My
person.
lords, the petitioner holds 8,000 shares of total 10,000
What?
shares.
8,000 or 10,000 or whatever may be, the company's liability cannot be taken from the director like that.
My lords.
It's not heard of.
That is my instructions, my lord. I filed the affidavit on the basis.
Understood, but see to it, I don't think that is permissible because a company
Is
a
it?
partnership firm is a different aspect.
My lord.
Yes.
A company is a juristic entity by itself.
Yes.
My lords.
So therefore, you have to initiate the proceedings against the company.
Understood.
You see how the things, the company has to be initiated. It may go for liquidation. It may go for whatever may be. You may initiate whatever proceedings against the company.
My lords.
You may take over the assets of the company. Once all assets are there, then if there are any guarantees by the company directors, then you can initiate the guarantees. This is how against the company. Not this in this manner. This is absolutely without jurisdiction. And against them that you like to so-called initiated against your retail license. Action should not be initiated against the for non-payment of this. That there is no provision to that. Very difficult.
Well, let me have some specific instructions, my lord.
You do one thing. You withdraw this so-called notice and initiate properly. Because if I pass an order and set aside this, you'll be stopped from taking up other actions that will have a forensic.
My lords.
The moment I say that you cannot initiate against him,
I understand, my lords. That everything stops, my lords.
everywhere it goes,
My
it
lords.
will affect you a lot. So better you withdraw this they initiate the action against the company. Issue a notice to that effect. Ask then how they are liable or not, how do they want to do? Because for cancellation, you have to do under 30.
30, my lords.
Section 13, isn't it 30?
Well, 13 is section.
30.
30, section 13 or 30.
If any duty fee payable by the holder thereof has not been paid, that is only for him. If excisable article is sold at excise price, these are the reasons by which you can go for cancellation. You cannot exercise the power of cancellation also. Who are that person?
Let me have some specific instructions. If they given written, my lord.
When?
Next
When do
week.
you want?
Next week. Yes.
Mr. D. Gogoi, the learned counsel, appearing on behalf of the petitioner, submits
not
that
petition.
he would like to obtain specific instructions from the respondent authorities
Petitioner will.
on the aspect pertaining to the legality and validity of the show cause notice. Who are the petitioner? Is this matter again on
20th, my lords. 20th August.
20? 20?
Yes.
No, this small matter.
Yeah.
On 21st August 2028, 26. Interim
my
order
lord,
passed
that-
earlier shall
My lord
continue
just
to-
stated me as a petitioner, my lord. I'm going to respond. That order sheet, my lord, lordship just passed me as a petitioner, my lord. So I'm not the petitioner.
No, for the respondent.
No,
Who are the petitioner?
There is an interim order, my lord.
Interim order to continue.
Deeply blessed.
Public. May it please your lordship.
Yes, what is this?
Lordship, the petitioner submitted tender in terms of the tender notice dated 12/1/2026, Lordship. And annexing all the required documents, including the one indicated at clause 8 and clause 15, Lordship. And subsequently, his technical bid has been rejected, Lordship. And thereafter, fresh notice was invited, Lordship. Our main contention
After
is
a
that,
long order,
yes, Lordship. No, Lordship, the amendment.
after this order has been passed by the learned coordinate bench, where do you give me the room to move anywhere?
Lordship, the learned honorable court was on that day just form of the opinion that the petitioner has a prima facie case, Lordship.
Then why there was no interim order?
Interim
passed?
order, Lordship, keeping in view the public interest, Lordship. That has been indicated in the order.
The fresh tender has been published on so and so and the last date of so and so. From annexure A, B, C, D, it is evident that the P so and so are to be transferred under so and so. The reason to publish the fresh NIT within the period of 14 days has been recorded in the minutes. Regard to the public element involved in the bidding process for selection of Iman or the alleged violation of the AI as a tender, this court is primarily no interference in the form of any interim order staying the bidding process indicated by so and so is called for. Now, what has happened in the meantime?
Lordship, in the affidavit filed by the respondent,
Where about that? In the meantime, what happened?
in
Regards the tender.
tender, Lordship, whether it has reached finality, we don't have the information as such, Lordship. In the affidavit also, there is no indication, Lordship.
Yes, I have also no information latest position. However, we have filed our affidavit.
An advocate should do something better. The tender notice, there was an urgent, this court had passed the order on 26/2/2026. Taking into account public interest, the court said that we are not staying it. And after 6 months, if we come to learn that you don't know what has happened, this is the sad state of affairs, Mr. We stayed it then. Because for the last 6 months, if you have not done anything, then what is the only ground on which it was not stayed is that.
My lord,
So we stayed.
no, regarding latest position, Lordship may fix it tomorrow, day after tomorrow.
Day after, Friday.
And regarding merit of the case, we are ready.
Not merit of the case. Find out what has happened. In the meantime, if it has been granted to somebody else, the tender, the writ petition has to be then amended, file a
Yes.
fresh
Well,
writ petition.
well.
We cannot, why should we look into this petition like this? Because then third party rights have already accrued.
Well,
We cannot proceed and do it this manner, and later on we again, the third party will come and review. Mr. So-and-so, the learned counsel, if you learned junior government advocate shall apprise this court as to what transpired and as to whether that evaluation of the notice inviting tender for selection appointment of the handling and transport contractor for transportation of food grades under NFSA 2013 of Lakhimpur district have been finalized, and further as to whether any bidder have been selected. List this matter on Friday.
Please, your lordship, we have received the objection copy from the other party. Lordship, on the earlier date, my senior Darakulla was present before this honorable court. Today, due to his ill health, suddenly he couldn't appear. So lordship may kindly grant another date.
We have filed the affidavit. Matter pertains to cancellation of tender, my lord, after opening of the financial bid. He was the L1 bidder, sole L1 bidder. It has been cancelled. So, my lord, probably the record will also be necessary, my lord, to peruse the, my lord, decision.
There's a stay.
But there is a stay, my lord. That
Stay.
lordship will fix it. Otherwise, my lord, short issue. The ground is justified, of course, will stand.
Tender for what?
My lord, it's regarding private ward of the, my lord, Joran Medical College. Some urgency is there.
Oh, matter has to be taken up urgently.
Yes. On a hearing, they, my lord, they have to any day.
30 crores, 10 lakhs, so and so. Miss so and so appearing on behalf of the petitioner. You are not filing a reply. Submits that on 6/8/2026, the affidavit has been filed by the respondent number 3. The learned counsel submits that an opportunity may be granted to the petitioner to file reply there against, taking into account that there exists an interim order. This court fixes this matter on when?
My lord, any day convenient, my lord. At 2, my lord, it will be more convenient.
After 1 week, my lord.
On 19th of August 2026 at 2 p.m.
Not sir.
for final disposal. Petitioner shall be at liberty to bring on record its stand by filing the affidavit in reply on or before 17th of August 2026. Interim order passed earlier shall continue till the next day.
May it please your lordship. Lordship, this is non-payment of contractual bill, my lord, amounting to
Department,
Home Department, my lord. On the last date of listing, my lord, some instruction were sought from the responding counsel.
yes, home.
Instruction is there, but admitted amount is not here, lordship. So, lordship,
Okay, pay 6 months,
lordship.
verify and pay. Direction to DGP,
Lordship.
the police, verify and pay.
Highly obliged.
This is also my contractor bill, my lord, non-payment of PWD, non-payment of
My
contractor.
lord, the work was, my lord, in respect of respondent number 1, executed by PWD. So both respondent 1 and my lord, 2 will be the authority, my lord, to verify and make the payment.
Work was
1 is the Legislative Assembly, my lord. And work was construction and upgradation of VVIP parking area of the Assam Legislative Assembly building campus at Dispur. So respondent one will make the payment, PW will make the verification, admissible amount.
You verify,
Yes,
let the PWD verify the amount.
and one will make the payment.
Respondent numbers 2 to 6. Verify the amount
Right.
and then pay. Verify the amount within 1 month,
Lordship,
and thereupon the payment be made by the Legislative Assembly
Lordship,
within 6 months. Therefore,
Lordship.
1 month or 6 months. Payment here probably what the payment has to be made by rule number 1 on Legislative Assembly, but the verification will be carried. So verify as to the entitlement in 6 months thereafter by the sum will respond. Copies of the certified copy be served upon the chief engineer as well respond number 1 to Nasir 1 to Namtu. What is this?
This regarding issuance of license, my lord, of license, my lord. In the meantime, my lord, they have filed affidavit, my lord. Sometimes will be required to file the reply, my lord. 3 weeks time may be granted, my lord. To get some information, my lord, I have filed RTI, my lord. That is why.
What is your stand?
Also, there is a educational institution, Lordship, nearby.
Huh?
One educational institution is there, Lordship.
What?
One school is there, Lordship. Private school.
Private school there, my lord, whether it is
150 meters.
Yes, Lordship. Yes, Lordship.
whether it is recognized by the government or not, that has to be
Private school, Lordship.
that has to be brought into the record of this honorable court, my lord. Since
Does it say? Does it say anything as school or schools of the provision says schools?
schools, it is private schools, of course.
So private school will come in. Why do you need the government?
No, as per the provisions, and lordship also passed the order to that effect. I have
That-
seen one order that whether the school is private or
I've
whether
never
it is
passed it.
recognized or not.
I have never passed that out. If it is a school out there, school,
So I should get some up-to-date information, and
you want to, in the meantime, you want to remove those schools.
no, my lord, if there is no such this recognition, then certainly the provisions will come. And otherwise also, if not, then all
So, what is the name of the school?
some school.
You must have had the certificate.
So that I have already applied for, my lord.
No,
Right.
you are mentioning, you must have made an inquiry.
Yes, Lordship. We have made that.
Where's the inquiry report?
Yes, page 53 of the writ petition, Lordship. Page 53 of the writ petition, Lordship. Down, Lordship.
Yes.
Down.
That is his application.
No, it's a report, Lordship. However, a private educational institution is visible on the opposite side of the applied liquor shop. Upon inquiry with the local residents about the private education institution, they informed that the institution was established 2 months ago, but class have not been commenced. This is another report, Lordship.
Class had not commenced.
Kindly see, Lordship, page 58, Lordship. That last, there is also a private education institution within 50 meters of the proposed IFL observed the education institute, namely National Grammar School.
This is given by the Assistant Commissioner Dhamaji.
Lots.
An affidavit has been filed by the respondent number 5, providing the reasons as to why the petitioner's application have not been considered. Mr. B. Chetri, the learned counsel appearing on behalf of the petitioner, submits he would like to obtain instructions and file a reply. this matter again on 16th of September 2026. In the meantime, the reply be filed on behalf of, reply be filed by the petitioner.
Obliged.
In the meantime, liberty granted to file the reply by. What is this, madam?
Lordship, page 14 is the liability statement, Lordship. It's a admitted.
Water resource.
My lord, we have filed our affidavit, my lord.
Who has to pay?
Lord, this
Water
is,
resource.
this is under that flood management scheme, my lord.
Huh?
And this is under flood management scheme. So we have, our instruction is an affidavit we have filed that we have not received the amount from the central government, my lord.
Central government.
My lord, the central
The
share
central
is not
government is
received.
the or is their
Yes, already
party?
party.
Union of 1 and 2.
What?
Sometime will be granted, lordship.
Lordship, it's a small amount. Let them verify and pay, Lordship.
Well, if
Page
the money
14,
has not
it's
been
the
paid,
admitted amount, Lordship.
how much?
1,24,000.
10 lakhs 87,000.
Lordship, part payment already made, Lordship. Balance amount is 1,24,000, Lordship.
Amount payable when?
My lord, this petition has been filed after 12 years, my lord.
Oh.
2014, the work was completed.
No.
And my lord, the liability.
Why have you approached this court so late?
Lordship, page 13 is the RTI reply, Lordship.
So what? RTI doesn't have anything to relevance out there.
They are approaching the respondent, Lordship. They are not being paid
No.
today.
You can't approach this court so late. You have taken the plea of
My lord, we have taken.
delay.
Yes, ma'am.
You have filed your affidavit.
Yes, Lordship.
Ms.
What a
P. Chakraborty, the learned counsel appearing on behalf of the Water Resource Department submits an affidavit has been filed, wherein the plea of maintainability of the writ petition on the ground of delay in latches have been taken. Ms. So-and-so, who appears on behalf of the respondent number 1 and 2, 6 for an accommodation. Full stop. Taking into account the above, list this matter again on 7th of September 2026. In the meantime, the respondent number 1 and 2 shall bring on record its stand by filing the affidavit. What is this?
Lordship, it's a disconnection notice under 126. Affidavit was to be filed, Lordship.
There was an inspection carried out at the premises of the petitioner, my lords. The petitioner, my lords, has also, it is otherwise admitted in the writ petition also, was found to be using a domestic connection for carrying, was found to be a domestic connection for commercial activities. She was running a paying guest, my lords, PG. So, my lord, that is otherwise not disputed. There is an inspection, but the subsequent procedures, my lords, as required under the act, they have not been followed. I must fairly submit, my lords. We should have given them an opportunity of filing their objections, gave them an opportunity of hearing, then proceeded to file a final assessment. Now, straight away, there is a disconnection notice. If that happened in the past also, there is an order to that effect, my lords.
So there is a provisional assessment.
Yes, there is a provisional assessment.
So then you have gone into final assessment.
It has not even gone to a final assessment. I don't.
Directly without the provisional assessment, they have issued the final order. Date 2, the inspection report has been carried out by officers who is not the assessing officers, just somebody. That is also the inspection.
That is covered by Lordship's judgment.
That is settled.
Yes.
Yes, Lord.
As far as the subsequent procedure is concerned, my lord, I have to be fair, my lord, that has not been followed. So if Lordship's permits, my lord.
So there is no provisional assessment.
There is a provisional assessment that was carried out.
Where is the provisional assessment?
There is a bill. No, it is otherwise also.
If this is the impugn order at page 37.
Where is the inspection?
Yes, the 36 is the provisional assessment. The inspection Lordship will find at page 23B.
36 is the provisional assessment.
Yes, ma'am.
Then?
Now straight after after issuing the provisional
Notice
assessment.
for disconnection.
Yes.
Then what?
Then, my lord, the payments have been made, my lord, the
Regular payments are being made, Lordship. The lady who is a senior citizen of 76 was only 4 girls were there, Lordship. Other, the nearby also there are hostels running, but only in my PG it is done.
the
It is
inspection, my
not
lord, so that-
commercial, Lordship. It is just to get a fulfill the basic requirement. And Lordship would see the inspection report. The inspection, it was found only 770 watt.
Huh?
My existing load was 12 kilowatt. Lordship would see it at page 24, the inspection report. Only total 1770 watt was found to be running.
This is the
Wait,
case.
wait, wait.
Page 24, Lordship would see. Page 23, sanction load is 12 kilowatt, Lordship.
And then
Page 24, during inspection, next page,
yes, what is it?
what was seen to be running, that total is 175 watt.
What is 1775?
Watt. Yeah.
Only what? That has no relevance, but why do you say it to be commercial?
My lord, for the reasons as per the explanation under 126 B4, my lord. That it says for the purpose other than
Electricity,
for which the electricity was authorized, my lords.
Huh?
126, section 126(6), subsection 4, my lords, the explanation.
I think it's item mistake also, not that.
Oh, it's
75 years old. I think somebody out there.
We know, Lordship.
Okay, I think PDCL has better things to do. Who is required to take commercial connection?
Yes, Lordship. Lordship, I have brought out a notification.
You are referring to 126?
126, subsection 6, explanation 4, my lords, B4.
The purpose other than for which the uses of electricity was authorized. Okay. Now keeping these 4 girls out there, you mean to say that it is commercial?
I think there's a commercial activity. That is the
Not commercial activity. Is it otherwise considered, how many, is a PG to be a commercial activity?
Lordship, she is earning nothing, I am telling Lordship, she is earning nothing at all. How she is living, Lordship, I know.
Don't personalize yourself with the client.
Yes. That is perhaps not the right
Really,
case, my
Lordship.
lords.
Anyways, whatever it may be. Nityananda Soikia, who is the consumer?
Lordship, her husband has expired, Lordship, but it is being continued in her husband's name. But he is the beneficiary now.
It has not still come in her name.
It has not.
New Soikia. You've got to stay.
Yes.
During inspection, category violation was found. Necessary action will be taken as per APDCL. Hello? Show me what who falls in commercial and who falls in domestic. কোন কিতাপখন দিয়কচোন, আৰু এখন আছে। এনেকুৱা আমাৰ আছে। Yes, where?
Yes, Madam. Sir. And this is actually a part of the tariff, my lords.
Huh?
This is perhaps part of the tariff order, my lords, of the AERC. This perhaps will not have it, the categories, industrial, commercial, and
Because in your, this
yes, it's
such inspection report,
APDCL norms.
of category violation. So category K violation has to be on the basis of this only? Apply code, installation of meters, because the initiation has to be on the basis of this.
Rightly, ma'am. No, the classification otherwise, my lords, as regards the classification, my lords will find at page 17 of this very code, regulation 2.3.
17.
17, yes, page number 17.
Okay.
2.3, my lords.
B, Lordship, B. 2.3B.
Now 2.3B, having not been complied, how can you initiate any proceedings?
Yes.
Huh? He said it like this. At least do something for senior citizens.
My lords, if my lords permits, if otherwise possible, my lords, may I try and impress upon the APDCLs to withdraw these proceedings
I
without
think better off.
some other day, my lords, I'll try and impress upon them.
I think you do it, otherwise this court is going to set aside on the weekend. Find it out, don't forget, 2.3B. I may not be taking up against this bench files. Oh,
I'll point it
so
out.
you just remember this, 2.3B.
Yes, Lordship.
When it is a change in a classification, because here it's a category or whatever it may be, there is a requirement of issuance of a notice.
Notice.
I'll point it out, even if he doesn't, my lords.
I may not be here. This court have heard the learned counsels appearing on behalf of the parties. Upon perusal of the materials and record, it is seen that the reason why the proceedings under section 126 of the Electricity Act 2013 have been initiated against the petitioner is on the ground that during inspection carried out on 10/2025, it was found that there was a category violation. This court inquired with the learned standing counsel appearing on behalf of the petitioner, a respondents, as to what is the category violation. The learned standing counsel had submitted that the category violation was that the petitioner herein had used the domestic connection for commercial use by using her residence as a What is PG full form?
Paying guest.
Paying guest. Accommodation. So this court inquired as to whether prior to initiation of proceedings, was it not the requirement of clause 2.3 small b of the AERC Electricity Supply Code and CE Installation and Operation of Meters Regulation to issue a notice to the petitioner, thereby granting the petitioner an opportunity of hearing? The learned counsel appearing on behalf of the APDCL has submitted that he would obtain instructions in that regard. So, taking into account, this court also finds it very relevant to take note of that the petitioner herein is a very senior citizen. And therefore, there is a requirement of an early culmination of the present proceedings. Accordingly, list this matter again on 17th of August 2026. Interim order passed earlier shall continue till the next day. What is this?
Well, farm development, my lord. In the meantime, the impugn order has been withdrawn, my lord.
Withdrawn.
Yes, sir.
Now, your product development done.
No, my lord.
Oh, you're lucky enough. Mr. H.K. Sharma, appearing on behalf of the petitioner, submits that the instant writ petition has become infructuous in view of the fact that the impugned farm debarment notice dated 13/11/2025 have been revoked by the respondent authorities. A copy of the order of revocation have been dated 2/7/2026 have been placed before this court, which is kept on record and marked with the letter X. Taking into account the above, the instant writ petition therefore stands closed as infructuous. What is this?
Also, there is a possession notice from the AFC Lordship on last order 17/7.
And avail the loan from AFC under a scheme for settling.
Lordship,
setting
Lordship
up
may
a
peruse the order.
financial assistance of the MT and the project was for an amount of rupees a month. Okay.
I was directed to pay 15 lakhs.
So, interim order, however, be reconsidered under Iman in view of the equities and if the interim action is not put on hold the petitioner's deposit. An amount here within a period of 2 weeks will expire on. Yes, what is this?
I have paid 15 lakhs 10,000 Lordship as per upfront amount as per this order Lordship.
Then?
Lordship, what has happened?
File your affidavit.
Yes, Lordship. No, Lordship. I have to file, Lordship.
You want to file?
Yes, Lordship. I want to file.
Oh, urgency.
No, yes, urgency, Lordship.
Lordship,
Lordship, tomorrow,
Why haven't you filed your affidavit then?
within 1 week, Lordship.
Then
I will
on
file.
one hand, you don't file an affidavit and you say urgency is there.
Lordship, we received the additional affidavit from their part, Lordship.
Where about the additional affidavit? Additional affidavit says that they have deposited the amount.
yes, and I also they picked the flood situation.
They
Lordship,
have it in the month of February 2027.
Lordship, tomorrow I will going to file, Lordship.
Lordship,
Tomorrow, Lordship.
Lordship, one thing I wanted to submit, Lordship, after on 17 this matter was taken up. On 18 there was heavy floods in Sibsagar. All my carrying vans have been now been so for the next payment some time would be required, Lordship. My carrying vans are totally so that thing also I have put in my
How much amount you have to pay?
Lordship, what has happened? 145 I took. Around 90 lakhs I already paid before filing this case. 15 lakhs I paid on 31st July.
You are from Sibsagar?
Yes, Lordship. Sibsagar, that to
Amguri,
Amguri.
Lordship. Amguri, Lordship. So far, Lordship, regarding the flood plea, Lordship, that was resolved, Lordship. Now, that was resolved, now regarding the root condition, Lordship, now it is, now root condition is normal, Lordship. Within a week, it was solved, Lordship.
You admit there has been floods.
Yes, flood is admitted, Lordship.
You admit
Yes.
there has been a lot of destruction on account of the
Yes,
floods.
yes, Lordship, discussion. But Lordship, regarding the selling, he took the plea for obstruction of the selling of the product, Lordship, of the of his company, of his factory, Lordship. But that count, Lordship, I don't think that this flood will affect, Lordship.
You file your reply?
Yes,
When?
I will.
When?
Lordship, day after tomorrow, Lordship.
Sure.
Yes, Lordship.
Mr. J.K. Goswami, the learned counsel appearing on behalf of the respondents, AFC.
AFC, Lordship.
AFC submits that the affidavit would be filed within 2 days' time.
Lordship.
This matter on 24th of August 2026.
24.
The affidavit on behalf of the respondent number 2, 3, and 4 be filed on or before 14th of August 2026. Liberty given to the petitioner to file reply on or before 21st of August 2026.
Lordship.
The interim order which was passed on the last on 17/7/2026. That this court also takes note of that in pursuance to the interim order passed on 17/7/2026. The petitioner had deposited the amount of rupees 31,700, deposited an amount of rupees 15 lakhs, na?
10 lakhs 10,000. 15 lakhs 10,000.
15 lakhs 10,000 on 31/7/2026, and a receipt thereof have been enclosed as annexure 9 and 10 to the additional affidavit. The learned counsel appearing on behalf of the petitioner further submits that on account of the floods in the district of Sibsagar, the petitioner may be considered certain interim directions, the interim directions which was passed earlier be continued till the next date. Accordingly, till the next date, comma, the respondent AFC shall not further insist. This court shall further reconsider on the next date subsequent to the filing of the affidavit by the parties. Lordship.
Deeply obliged.
May I please, Lordship?
Very
I-
nice.
Electricity, my electricity disconnected by the respondent number 5, my lord.
Your electricity?
Disconnected, my lord.
When?
5/6/2026, my lord. Thereafter, petitioner filed application, my lord, page 157.
Why it has been disconnected?
My lord, there is a adjacent area, there is a eviction going on, my lord.
Huh?
In the, my lord, Ulubari area, my lord, Birubari area, there is a eviction carried out by the respondent, my lord, in the adjacent house of the petitioner's, my lord.
And did you get a stay there? Did you get a stay there?
No, my lord, there is a pending case, my lord.
Huh?
There is a pending case, my lord.
No. Yeah. Eviction. There's a mic for you too there. Yeah.
This case, my lord, pertains to that tag number 97 of TB hospital. My lord had dealt it at one point of time in a batch of writ petitions.
They're still there?
Yes.
Yes,
Yes.
some of them are there. Now, pursuant to my lord's order, my lord, to the exercise as contemplated, because lordship has formulated certain points for determination. So those who have complied with speaking orders were passed in accordance with Salakuddin. Then those speaking orders were put to challenge, my lord, before the coordinate bench of this honorable court. That challenge was negated, writ petitions came to be dismissed, appeals filed before the Honorable Division Bench that there to my lord, no relief. So finally, those persons, almost 26 numbers of households, they were evicted. Now, some households still remain. Now, here is a case, this is one of the petitioner where my lord speaking order, this is one of the petitioner where speaking order has also been passed by now, but they are not evicted. In the present writ petition, the complaint is my lord that their electricity has been disconnected. I have taken specific instructions from the district commissioner. He says that we have not interfered with the electricity connection. So this is purely a lease between the petitioner and the APDCL authorities.
No, you should remove this electricity. Then only things, this will only, if I remember the judgment of the Supreme Court in the case of AF, what is the name? KF? No, AF Kennedy. AF Kennedy. There, in respect to these forest areas, there was a specific direction that in order to make these petitioners no longer necessary to remain there, the disconnection of the electricity is the perquisites. Then,
My lord, in this case, my lord, my learned friend stated that
why you are allowing them to remain without electricity?
We have not interfered with any, with the electricity.
No, you have already passed a speaking order against them.
the speaking order is challenged.
Now been put to challenge by.
Challenged.
That is another petition pending before this honorable court.
There stay.
There is stay.
There's a stay in that order.
Yes, there is a stay.
Where?
Page 150.
150.
Yes.
150.
Yes.
The resolution is disposed of.
No, my lord, it is pending, my lord.
Notice has been issued, but the direction which has been passed is if it's like till such determination is made, the respondent are required to abide by the observations made by the division bench as quoted above. What is the directions?
That direction is, my lord.
That in fitness of things, it will be appropriate to direct the respondent more particular to consider this aspect of matter while carrying out the exercise. In addition to that, it is directed that while carrying out the exercise directed herein about, the claims made by the appellants as regards the status of the air shall be considered. Taking into account the construction is already complete and the land occupied by is required for future expansion of area in a considered area if it is provided. That till such determination is made, no coercive action shall be taken to demolish the existing dwelling houses of the appellants.
Now, post the speaking orders.
No, thereupon there is no, there appears to be some review.
Yes, we have also filed a review.
A review petition was filed by the and was prepared in the review is in the order. The division bench has observed that no review of the judgment was called for.
No,
Then there was another order passed, if I am not wrong.
Yes, there was another order.
Whereby it has now this order which has been passed by the division bench.
Yes.
I think that has been tinkered with.
Yes.
No.
Yes, it has been.
It says that because of this now the very use of this new TB hospital, the medical college have become difficult.
Yes.
So there has been some order passed.
Yes, in the review. Now what has happened? Lordship has seen this, my lord, division bench observation, my lord, system in the writ appeal, series of writ appeals.
This is the first writ.
Writ appeal.
This is the first writ appeal order. Because after the single judge passed that order, The matter went to the division bench.
And this is the
The
first
division
iteration.
bench passed these directions.
This direction.
But thereupon there is some review.
Yes, there is a review.
There was an initial review filed, then again there is another IA filed or something to that effect.
Yes, yes, yes. Now, my lord, in that review, the honorable division bench has clarified this portion of the order and said, my lord, that okay, fine, your contemplation for further rehabilitation will may be taken care of by the state, but first of all, you have to live.
Where is that?
That order is here.
That is the I have to. I tell you, not
It's there.
second half onwards, I have been doing that only. In view of that order,
Yes, my lord.
can the petitioner be entitled to any further interim relief? In the writ petition. That is a very recent order, if I am not wrong.
Yes, yes, in the review, my lord, that is order dated 4th of June 2026.
You have enclosed that, Mr. Counsel?
No, that. No.
They will not enclose that.
So therefore, this court has passed that order.
My
Hey,
dear Milord.
Anybody has that order?
I'm having, I'm mailing it, my.
Because till determination, if there is a question of a determination, then the question will arise that yes, for a temporary period, they should be granted the electricity. But if that review order has been passed in this manner,
Yes.
then I don't think there is a requirement of any electricity.
Yes, it's there, my. Review 89 of 26. Review petition 89 of 26.
Here it is.
Four six order. 4-6.
Here, लगाई दिया होगा. Now करो. हमारा स्क्रीन ऑनलाइन ही की. क्या? डाउनलोड करछन डाउनलोड कइले ओले जाबो तो. डाउनलोडर सीन ना था. Mr. Ardhar was the main person. He has done so many matters on this.
Yes.
Should they say review? He has now taken out one order from the apex court which appears well that the review order has been stayed.
Yes,
That
Lord.
person only borrowed.
By
who went to
order
the
dated
apex
4/6/2024,
What happened?
3/8/2026. The SLP E23809 of 2026.
What does it say? See, last keeping in mind that this court had by the judgment sought to be reviewed, directed that the exercise of assessing the claims of the respondent for the rehabilitation to be completed within a period of 90 days to be counted from the date of the delivery of the judgment. In the meantime, they have not been evicted. Learned revocation, this was the exercise was completed within the and the claims of some in the first instance of twice. Reason for filing the review when the action has been complied. For the sake of clarity, and at the rear, paragraph number here, taking note of the submission. The response of and disposing of the appeals, the respondent. With the consist. Keeping in mind that. Keeping in mind, keeping in mind. that Such an exercise is considered completed. That will be. With the only clarity. There should be dissatisfaction with the mother's part. Which we have certain steps. So therefore,
The second last paragraph.
the second, so their reconsideration will be for any other land as per the land.
Any others, because they are harping on again and again and again and again.
So therefore it will be in some other land. Now what has happened, Mr. Dhor, as regards this order?
These persons have already been evicted, madam.
No, 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 no.
Yes, yes, they are already.
No, my lord, no, my lord. We are still there, my lord.
No, 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 I am not talking about the repetition.
Yes.
This person, Monmil Boro and 26 others. Now, my learned colleague, Mr. Dhor, has shown one apex court order. However, it appears, my lord, that Monmil Boro has now gone to the apex court. But that person, along with 26 others who were party in those.
What has happened in the apex court?
Apex court, they say, my lord, that it has been stayed. It has been stayed.
Yes.
Order of the review.
Even if this review order is stayed, then also, my lord, it cannot operate as a status quo ante. Because by
No, not against that. But if that review order is being stayed, because you see, the learned single judge coordinate bench had passed an order of not to disturb them till the determination is carried out.
Second leg of determination.
Second.
Second leg of determination.
Now that determination you have not carried out.
That process has already been initiated. But that
No, determination for the purpose of rehabilitation.
Yes.
But in the review order, what they say that, okay, that will be considered. But in the meantime, they need to vacate.
You have to vacate.
So that order have not been taken into consideration by the learned single judge, by the coordinate bench. But in the meantime, if the review order has been stayed, then obviously it has to be taken that the order which has been passed by the learned coordinate bench in the petition still holds.
Yes.
And thereby he is therefore entitled to the electricity.
Yes. It is
Where is that order?
This is the order, lordship.
Yes, why haven't you given the electricity there?
My lord, today morning also we have visited the site, my lord, and we have come to know that, my lord, some of the petitioners were evicted and there are vacant land also, my lord, evicted, my lord. So if they are in the position of the.
No, we are in the position.
So subject to
How many
verification.
persons are there?
Will grant them electricity, my lord.
I have two petitions, lordship, 55 and 56. Since your lordship's order is still holding the field, at paragraph 50, lordship's judgment,
Which
07 11 2024, is categorically passed, lordship, at page 21 of the order dated 19/6/2026.
Page?
It's 21, lordship.
21?
21
71?
of my 55. Petition.
I don't know. I'm taking a 54.
No. 55 and 56 is mine.
What does it say?
That's from page 19, lordship, property portion lordship's order, which has been quoted in the order dated 19/6/2026 at page 21, paragraph 50.
So therefore, therefore, that is what Mr. Dhor I was saying.
Yes.
This order would hold good if there is a stay to the directions passed by in the review order.
Yes.
Now in the review order, There's a stay. That is what you say.
Yes.
So therefore, if they are in occupation of that property, they need to be granted the electricity connection.
Yes. And Lordship's order was specific that the appeal which will be filed by the petitioner shall be disposed of within a period of 30 days. That appeal has not been disposed of in my case.
Everything has been done because if we go by the sequence of events, at the first point of time, Lordship was pleased to dispose of that batch of writ petition with 4 particular minor points for determination to be taken up by the authorities at paragraph 50.
What are these photographs? Who have given these photographs?
My lord, APTCL, my lord. Today morning they have visited the place, my lord, so that any reconnection can be done or not. So since the meters have been already been taken out from there, they have to apply fresh connection. We'll consider that, my lord.
What about this house?
My lord, that we could not determine which house, whose house is this, my lord. So if they apply, my lord, fresh.
We do one thing. These are the 3 writ petitions. No?
Yes, my lord.
In the 3 writ petitions, revenue is the party respondent only in item 54, the first writ petition. And in
No,
the first-
we do one thing. They are otherwise protected by some interim order passed by the learned coordinate bench.
Ordinance
In,
and the speaking order has also a part of the record, finance speaking order.
there, but then also it is being protected.
Yes, yes.
In view of the judgment passed by the division bench, they are still protected in that writ petition. That writ petition is pending.
That determines, second leg of determination. Yes.
That is pending.
Yes.
Now, therefore, we can direct the
Because
who is the officer there? The subdivisional engineer. Huh? Subdivisional engineer, APDCL,
Yes, my lord.
4 and 5. Give us one person. Any of the petition, it's the same area. Who is the officer?
adjacent to each other, my lord.
APDCL.
They've not met for my lord. This Ulugari, my lord.
So they had an electricity connection. Okay.
Alia had.
Earlier. Now that electricity connection have been removed.
Removed, and meter also has been removed on
Okay,
11.
the meter has been removed. You have the meter number
Yes.
earlier?
Appears
No, it is there, na? So we direct you in the interim, taking into account that the petitioners are otherwise protected. Which officer will be proper? 4 or 5?
That 4, my lord.
4. Okay. Direct 4 or his delegate.
5, my lord. Subdivisional engineer, my lord.
Huh?
Subdivisional engineer, number 5.
Okay, 5 or his delegate.
Yes,
To visit, the petitioners will go there.
yes, my lord.
The so and so or his delegate shall go there, and you show the house of the year along with the earlier meter connection in your name along with identity, and if so, if they are there, then to submit a report before this court on the next date.
Yes.
So that we can dispose of directing the electricity. I think that is the only way for that.
Well-
Because there is an interim order by which they are protected. And if there is a stay, whatever, stay to Parliament. Okay. There is a stay to the interim order passed by the High Court. But those 2 persons have, you were not a party to those proceedings.
No,
You were not a party, no, you were not an appellant.
no.
They were not appellate. They were not appellate.
So this stay will operate for everybody.
Only, my lord, those 26 numbers of read appellants. or the opposite parties in the review application, their lordship will find. Only that 26 numbers of persons.
Lordship, we have not been evicted till date. Now, an appeal has not been disposed of even by the speaking order, Lordship, as
Which
per your
appeal?
Lordship's order. At page, paragraph
Now,
50.
there is a speaking order passed against you,
No.
for
No.
which you have filed the
In-
second round of lead petition.
In,
No, my lord.
in item number 55, 56, no speaking order has been filed.
speaking order passed against the item number 54.
In item number 54, we are a party respondent. So we haven't, we can look into the repetition. And in that repetition, we find that page 146. Page 146, we will kindly see my lord, item 54. That is Hamidas Khatun. Page 156.
There is a speaking order passed on 12/6.
Now, that speaking order has been assigned in the repetition. That lordship will see, my lord. It starts, my lord, from page 150 onwards.
Ah,
150 onwards.
ah.
That speaking order.
Ah.
Now, in that order, my lord, of 14/7, my lord, the honorable coordinate bench has passed this order.
No, but why it is open for the respondents as indicated in paragraph number 64 quoted above to proceed for a fresh and individualized assessment as regards each of the two petitioners in terms with the observations made therein. Now, why was it necessary for this court to pass that order?
Then, my lord,
More particularly taking into account that the speaking order was passed pursuant to the judgment passed by the learned division bench.
yes.
Huh?
Yes,
Why?
because of the reason, my lord, we had hesitated before the.
Where's the division bench judgment? Anyways,
Then judgment, my lord, in the read appeal, my lord. Yes, it is there. My lord.
This is 7/11/2024 is my judgment.
Yes.
And when judgment, they have not annexed, my lord, it is here, my lord. Lots of things.
We do one thing. Let us list this matter along with that writ petitions. List these matters along with that writ petition on another date.
Division bench judgment, it is there, my lord.
What is the date?
Dated, my lord.
No, I don't understand the reason why,
Yes.
because if the division bench judgment has asked you to consider as to whether they are entitled for settlement or not,
Yes.
and you thereupon, 27/11/25, thereupon on 12/6 you have passed that order, isn't it?
No, this is not in pursuance of the division bench judgment. This is a fresh speaking order.
No, but he's not entitled for settlement. That is why I could see that order. Where's the speaking order?
Yes. Now, my lord,
Kindly see page 146. This is a speaking order dated 12/6/2026. This is pursuant to the division bench order.
no, this is prior to, my lord.
How can it be?
No.
Division bench order is 27/11.
Lordship has disposed of those bunch of
Ah.
where all the persons were before this honorable court on board, my lord. Now, after passing of the order by your lordships, my lord, the exercise were taken up, my lord, hearing had taken place and individual speaking orders were passed. Not with regard to this petitioners, my lord, this petitioner, that had been passed at a belated stage. Now, in respect of 26 members of households, my lord, those speaking orders came to be passed. Similar to this kind of speaking order. Those were put to challenge before this honorable court. Now, honorable single judge has, my lord, dismissed all the writ petitions, saying that, my lord, upholding, my lord, the speaking order. Now, those 26 persons, my lord, who had filed those writ petitions, they went before the honorable division bench in retapping. Now, in the retapping, my lord, these observations came to be, my lord,
Asked.
passed. Now, this observation, my lord, primarily relates to, my lord, to the fact that, my lord, the state has been asked to take a second leg of, my lord, exercise, afresh, my lord, with regard to their rehabilitation.
So that is what I'm saying. This direction was given on 27/11/2025.
Those, my lord, retapping.
Whatever may be.
Yes.
Now, therefore, consequently, while upholding the validity of area, this court directs the more particularly so and so to undertake a fresh individualized assessment of rehabilitation claim of each of the appellants. So this is only appellants. Strictly in terms with so and so, and such assessments shall be verification.
Yes.
So this was the direction only those appellants.
Only those appellants.
Now, now this is 27/11.
27/11.
Now on 4/6/2026, a review order was passed.
4/6/26. By that time, the exercise contemplated in these directions has already completed.
Understood? It's okay.
Yes.
But in respect to the petitioner herein,
Yes.
at page 146,
My lord,
an order is passed on 12/6/2026,
12/6/26.
which
Now,
is subsequently. Now here the question is not for anything else. What is being stated out here is that they are not entitled for settlement.
they are not entitled for settlement. So therefore, they have
For which the petitioner has sought has already been reserved for so and so. The area is not during the hearing conducted in man was asked to vacate the land. She could not produce any substance proving that she has been residing on or occupying the plot of land prior to Iman, which is a mandatory condition for grant of settlement. In the light of the findings recorded in so and so above, resolution passed in so and so is hereby cancelled. So this was a resolution, some resolution was passed earlier.
yes, some resolutions were.
Therefore, so and so is not eligible for settlement of the said plot of land and is liable to be evicted in accordance with law.
This was the similar.
Now, this order has been put to challenge in this writ petition.
In this petition. So therefore, the coordinate bench taking two of their division bench order, saying that, my lord, finally at the end of the day, even if
But where is the question of the petitioners being considered for settlement, taking into account these directions? Let us see this.
Yes, my lord, that is
Therefore, in the fitness, or it will be appropriate to direct the respondents to consider this aspect of the matter while carrying out the exercise directed above.
Yes.
In addition, it is directed that while carrying out the aforesaid exercise herein, the claims raised by the writ appellant, so and so as regards the status of DAG,
Yes.
shall also be considered. The exercise shall be completed within a period of 90 days from today.
from today.
Taking note of the submission of the demand that the construction is already completed and land occupied by AI if necessary, until such determination is made, no coercive action may be taken to demolish the so and so. Now, in this order which has been passed, this is quad appellants therein.
Therein, absolutely. So
That
it
is
a
one.
order in person.
Now, what has happened? The petitioner have challenged the 12/6 order.
That is afresh.
Effect. But in that thing, what is also being taken note of, that the petitioners are not entitled to settlement.
Not entitled to settlement.
So
What-
therefore, if the
what
petitioner
don't-
is not entitled to the settlement, whether they will be entitled for other lands is a different thing, but that land cannot be granted.
That can, so now since that decision has been
Okay, we do one thing. No, we do one thing.
failed, my lord.
I think, in fact, with due respect to the division bench, they realize later on what they have created.
Therefore, my lord, rightly reviewed. Now it is, my lord, before that, because now, my lord, the apex court, my lord, these proceedings will also become infrastructure. So there cannot be any status quo ante. They already evicted, go.
Unless they move something. Anyways, I'm not concerned on that.
May-
So, taking into account,
Determined
taking into account that for the purpose of adjudication of the present batch of writ petitions, the records of WPC number, what are the other writ petitions?
Other petitions, Lordship,
81/2026
and 55 is 3895,
and
55,
comma,
55, 38.
3210/2026 and
3895, 3895/2026. In item
Why?
55.
3895?
Yes, Lord.
No. Oh, they have filed, 3210 of 2026 will be necessary, comma, list this matter again on 19th of August 2026, along with the said two petitions.
In the interim, Lordship, temporary connection maybe,
Not today. We'll have it on 19th.
because
Because
in the,
without that, main problem lies there.
Most pertinently, my lord, in the next two similar matters, my lord, we are not a party as per that.
Where?
In the, item
Item
number
number 54 and
56.
55.
because it is between the PDSL and the petitioner, Lordship.
No, the moment I am taking the other petition, you have been brought here, why?
Yes.
Only for the purpose that it is because of your eviction, they have not granted the connection. Therefore, they say that this authority to them. But one needs to understand that this is another round of litigation.
Yes.
Anyways.
I'm so obliged.
Right. But in this
What is
scorching heat,
this?
Lordship, they are to, in this scorching heat, Lordship, the petitioners, we along with their children are suffering immensely,
The
Lordship.
summers have already gone. Now it is month of August.
August is too hot, Lordship.
We'll see. We can have it before that also if you want.
Yes,
but I
Lordship.
think 19th is a close date. Before that,
No.
let's see on 19th.
Lordship. Obliged.
Liberty given to the petitioners to mention the matter for upgrading.
Lordship.
Yes, what is this? Mr. Borpuzari, you are again.
Lordship has directed, my lord, by last order, file an affidavit, my lord. We have just received all these instructions, my lord, along with details, my lord, particulars. And I am seeking a short accommodation, my lord, to file my affidavit in reply, my lord, against the additional affidavit.
Challenging the speaking orders by which allotment which were granted to the petitioner were cancelled, challenging the notices for eviction. Oh, that land.
That land, because they
I
have
still
filed.
remember you have given very poor land, means very bad land to them, which is for.
Allegation, my lord, and
which-
they had filed an additional affidavit enclosing there with certain.
I think you need to put that DC as well as the Commissioner and Secretary Revenue Department to wait during the summer hot out there in that sand for some time. Then they will realize what is the impact of staying there. In fact, the interesting part is normally near the river, it is very cool in the evening. But if there is a scorching sun,
Yes,
and next to it you are residing,
yes.
the hot, because of the heat from the water, it becomes unbearable.
But my instruction says with all photographs and everything, it is, my lord, very comfortably habitable. And all the basic facilities, PHCs, my lord, all, my lord, educational.
Okay, put the map
institutions.
also.
Yes, my lord.
The
We-
proper map where it is, where located,
Photographs
how much is
with-
the
With
distance.
Google,
The photographs is not there, but
photographs with-
photographs are very difficult, very dicey aspects.
no, my lord, we have given the coordinates.
Like
also.
here, you have some photographs somebody have given me.
No, but
One
this-
person is just putting
this-
his head in the
no,
other
but
matter.
This
put
photo,
some-
Lordship will kindly see, my lord, the instructions, my lord, this photo.
Anyways, you
Lordship will
file your
kindly
affidavit.
Yes, my lord.
No, but it can't be so long, but
Yes.
it's after all.
Yes,
Because there is a stay also operating.
yes, operating.
You have no urgency, I suppose.
No, urgency, my lord, because that power plant is going to be commissioned, my lord.
But there is a stay.
There is a stay quadra writ petition as well. It is a huge plot of land, my lord, almost 4,000 bighas. Now, out of 4,000 bighas, my lord, they are in occupation of almost 100 bighas. Periphery is 100 bighas. Periphery is 100 bighas, my lord. There is a
No
power plant,
problem.
my lord.
But there is no urgency. You have-
Urgency is there, my lord, because ancillary installation.
Then why haven't you filed after 2 months?
No, because they have.
We have it
of
in
late-
the month of January.
My lord, they have of late filed an additional affidavit to which we have to respond, my lord, kindly, my lord.
They
Lordship will
filed it
kindly-
on 10/3.
Yes, my lord, I take it, my lord. Lordship will kindly grant me, my lord, 2
Yes,
weeks
sir.
time, my lord.
In spite of specific directions passed by this court on 24/6/2026, neither the 26, Revenue Department have not brought on record their stand by filing any affidavit. Mr. R. Pujari, the learned standing counsel of the Revenue Department, submits that he has received the instructions and will be filing the affidavit within 7 days,
Can it be 10 days, my lord? Because some exercises.
within 15 days.
My-
Is this matter again on 7th of October 2026. Interim orders there.
Lordship, on the last date, it was not extended.
Okay, interim order past value stands extended
We will file it.
till
within 1
disposal
week,
of
my
the
lord.
petition.
Within 1 week, my lord, can it be in the month of September, my lord? We will file it, my lord, within 1 week, somehow, my lord. We will, my lord.
No, you said 15 days.
My lord, I will somehow, I will go.
Okay, 10 days. 10 days at Koriple, have it on the month of, on 23rd of September. Interim order passed earlier in the petition stands extended till the next date.
I am so grateful, my lord.
What it is? Mr. Bora, where are you? What is the matter
Lordship,
about?
go for the
Lord,
pair, my lord. Firstly, the pair. Pair of the
My
petition.
patra land and has been forcefully taken away.
I have a motion to take. Wait, I'm forgetting. I was thinking that not much matters. Wait. Yes, what is the prayer? Directed to complete the direct sale acquisition process or sale deed and pay compensation to the petitioner for the land and after payroll sale. Your land has been taken.
Taken, forcefully taken.
Then
Without any compensation, without any rational acquisition.
you have filed the affidavit.
You have filed a note, not forcefully taken, my lord. What has happened,
Who
my lord?
appears
There is a
on
dumping
behalf
ground.
submitted that he also
My
appears
lord,
for
forcefully taken away, my patra land, my lord.
Piece of the petition be served upon them.
There is
We
a-
have not filed a granted liberty. Did you file your affidavit?
Yes,
with the-
affidavit has been filed, my lord. What has happened? There is a dumping ground. Beside the dumping ground, they have here the land. So some part of the dumping has a spill over the land. That is being cleared, my lord. And thing is that he wants that that purchase, DMC should purchase his land.
Readings complete?
Reading is complete.
No, my lord.
Not complete.
Yes, my lord. Please is complete, my lord. They say.
You have to file any reply,
Not necessary, my lord.
okay. Taking into account that the pleadings in the present proceedings are complete as submitted at the bar by the councils, list this matter for final disposal on 28th of August 2026 at 2 p.m. for
I love less.
With regards to affidavit filed by respondent number 4, my lord, we have filed one reply today, my lord.
Respondent number 1 has also filed.
Yes, my lord. We have received today morning. Respondent number
Counsel appearing on behalf of the petitioner submits that the affidavit
1 week time.
filed on behalf of the respondent number 1 have been received by him today, and he requires some time for obtaining the necessary instructions. Taking into account the above, this court fixes this matter again on 7th of September 2026. In the meantime, the petitioner would be at liberty to file the reply.
I'm obliged, my lord.
67.
E. Bora,
Yes.
standing counsel appearing on here, submitted claims in respect to the book. Yes, National Health Mission.
Lordship, regarding this instant writ petition, we have communicated to the department If I may suggest something, Lordship, in Annexure A, since the letter is from the Joint Director of Health Services, from the Member Secretary of District Health Society, let them verify the claim, and if the claim is genuine, then the National Health Mission can give the payments.
So 6 months,
Lordship.
verify and fetch. It dispose, huh? This is the newly implemented response.
Yes, Lordship. Yes, Lordship. Much obliged.
What is this?
This petition pertains to declination of electricity connection to me in respect of the subject lane. And we want to file a reply against the affidavit filed by the respondent number 1 to 4, 7 and 8.
Counsel appearing on behalf of the petitioner submits that the petitioner would like to file an affidavit in reply against the affidavits filed by the respondents. Affidavits filed by the respondents. Accordingly, list this matter on 11th of September 2026. In the meantime, the affidavit in reply be filed. Okay, who will sub? Yes, you're ready with your
I'm sorry, Your Lordship.
liquid text.
No, something was troubling me in the morning. My mind was somewhere else, some personal issues. So therefore it got. Otherwise, anyway, I'm sorry, Your Lordship. What has happened, it should not have happened.
I have given you a good rest. Yes, I'll give you now.
Now, Your Lordship, there was an NIT issued by the Border Road Organization. Now, the Border Road Organization is situated at Balipara. It's in Tezpur. Now, Your Lordship has put a pertinent question to me that why you have filed this case here. The main reason is that the construction work starts at Balipara to till West Kamang district in Arunachal Pradesh. Now, page 99, Your Lordship, that's the NIT, part of the NIT. If I may draw Your Lordship's kind attention. 6.1 at the top of it, Your Lordship.
Bidding process
Shall be governed by the and constituted in accordance.
Okay, so you have the jurisdiction here. Now,
Yes, Your Lordship.
next,
Now-
the ground of rejection is that you did not have similar work.
Yes, Your Lordship. Now, that is not absolutely correct, Your Lordship. Now, if I may draw Your Lordship's kind attention to page 45. The nature of the work.
Yes.
RPF for slope stabilization measures at kilometer 114.200 at such and such hillside on road Balipara such and such. Now, next, the state, the name of the work, estimated cost. Now, page 46, Your Lordship. Two similar completed works costing not less than amount equal to 25% of the estimated cost each. The completed work shall consist of steel wire mesh, rockfall barrier, articulating block matrices. Now, they have rejected my case on these two grounds that I don't have the rockfall barrier and the articulating block matrices. Now, rockfall barrier with alarm system is fencing. That is a material. I need to procure it from the manufacturers and I have to install it on the side of the hill. For that, any contractor is not a manufacturer of that. He has to procure it from the manufacturer and he has to install it. That is the case.
Have you done similar work or not?
Yes, but I have not used these two material.
Then over.
No, Your Lordship will kindly appreciate the.
No. Whether you have this, you keep on going to Nagaland for doing matters?
I don't.
Yes or no?
I don't go. Generally, I
Don't
go to Arunachal.
You should go to Nagaland. If you go to Nagaland, then we'll see. These rock thing now is one of the most important thing, the steel wire mesh and the rockfall barrier.
Yes, Your Lordship.
Most of the places they have put it out there. And if you don't put, more particularly in a place like in Northeast, it is bound to have landslides.
Yes, yes, Your Lordship.
And you should have the experience of this. If you don't have an experience, do you have the other one?
Yes, Your Lordship. Your Lordship will kindly turn to page 153. I have done much more serious work at Kashmir.
Serious work won't do. Serious work many do.
Your Lordship will kindly see Your Lordship, page 143, 153. I have the work experience of slope protection, no doubt about that, your
No,
lordship.
no, you have to have the area of the completed shall consist of steel wire mesh.
That I have. Steel wire mesh I have, your
And
lordship.
rock fall barrier and articulating block mattress.
I'll come, your lordship will give me 2 minutes, I'll satisfy your lordship. 153.
Yes. What is this?
This is the work I have done under NHI DSL, your lordship.
Hmm.
This work was much more steep, your lordship. 2A, slope protection work, hillside wire mesh with bioengineering.
2A.
2A. First two, slope protection work, hillside. That is wire mesh with bioengineering. Now, slope protection work, hillside, high tensile rope net system with high tensile steel, wire mesh, hydro seeding with bioengineering, your lordship. I have done this wire meshing. Wire meshing is just like putting the fencing. Here is, they have named it rockfall barrier. Ultimately, things are same, your lordship.
Not for us.
Give
You
me
are
some
an
more time, I'll
expert. You
explain.
are an expert, Mr. Sinha. By yourself as Mr.
No,
R.
no,
Sinha.
no.
I'm
That
also
I
not an
must. No, what I'm trying to say is that it's only a work that need to be done,
I
your lordship.
cannot go into that expertise.
No, your lordship, let me just give me some time, your lordship. I'll try to say. I'll bow down to what your lordship says. But let me
Very
just
difficult.
explain it. Let me just give me some time. I'll explain it, your lordship. Now, this articulating mattresses these are fabrics. I have to put a cement inside and I have to place it on the slope.
This is from here.
Which one, my lord?
What? This is from here. You are getting your instructions
This
from
one
here.
from Tezpur, my lord.
Tezpur, your lordship.
Tezpur.
Get your instruction on Wednesday.
Yes, my lord.
Your lordship, one more thing I may say.
No.
One more thing I may say.
Mr.
While they have taken up the technical,
Mr.
decision,
Counsel, I would have otherwise be satisfied, but you don't have, this court does not have the expertise, Mr. Counsel.
your lordship, till that they have not opened the financial bid. They are supposed to open it on 5th.
No,
But
I'm not even issuing notice. I'm fixing it, list the matter on.
Wednesday, my lord.
till then they will not proceed, your lordship, that much. Till then, your lordship, give me some protection till then, your lordship. If I have a case, if I am able to satisfy it on that day, fine. Till then, your lordship will protect
If
me.
I pass that order, then the council, you see, one thing,
Yes, your lordship.
normally when the court rises, he gets, well, okay, let us pass that order. But my timing is, I always finish around 5:30. So I'm still half an hour short of not working
Yes,
today.
your lordship.
So therefore, I'm very fresh.
No, no.
So
I
therefore, the
appreciate
question
that.
is here that it can't be because I never pass. I would never pass. As of now, I'm not even issuing a notice to her. Will issue, I get her the instructions on Wednesday.
Your lordship will kindly allow me that day to make my submission as regards to what.
So on Wednesday you put it, whatever submission you have. But with this, unless you show that whatever work you have done at page 153, more particularly 2A,
Yes, your lordship.
would come within the ambit of the similar work,
Yes.
then you have a case. But if you not,
Your lordship, can your lordship give me till Thursday or Friday? Because I have to get the instruction from Bombay, your lordship.
fantastic, Friday,
Friday.
Friday.
I'm deeply obliged, your lordship.
Not
Grateful,
problem.
your lordship. I'm deeply.
the matter.
Your lordship, sorry for the morning. What has happened, your lordship? I'm deeply. I apologize from the core of my heart, your lordship.
You have to be because with your in fact I would not. I fixed the matter today in the evening because in the late hours today on account of for you to go. I was taking up a paperless court on last last Thursday, and while taking up when I was what
About to
they did
dictate.
is they have put the page numbers which are there in the index which we have not correlate with the page number of the petition. Which was so there I had a lot of difficulty. I understand you for you also, but that doesn't mean that the problem is when you are taking a matter on a motion day, it becomes very difficult.
It was my duty to assist. I deeply apologize, your lordship will
We'll
not
have
take
it
it.
on Friday.
I'm deeply apologize, your lordship.